is a general belief that if we're trying to advance people's best interests, and if we're trying to be protective, then actually we're not, as it were, powerful in the sense of that expression in politics. But actually, the combination of statutory authority on the one hand and a desire to protect and do good on the other is potentially a very toxic mixture in terms of how power gets exercised, particularly if people don't appreciate that they're exercising it. So that I want, as it were, to lay down that proposition and invite you to think about that proposition, especially if you have power and authority in the course of your work. I find it's very difficult for people in the caring sector to appreciate that they are arms of the state when it comes to exercising statutory powers. But that is exactly what you are, and we just need to be aware of it and the powers that we have. So that's the kind of place I wanted to start from, if I may. Those of us who have profound protective instincts, and those of us who are committed to trying to serve the best interests of others, have only two routes by which that can be delivered. The first is the consent of the person whose best interests we seek to advance. And the only other route is the use of compulsory powers against that person so as to secure their best interests. There is actually no other way of doing it. It is one thing or the other. And again, we need to be acutely aware of the grounds that we are treading on. The dividing line between the two is usually the question of mental capacity. If a person has the requisite mental capacity, then we may only do things with them, to them, and for them with their consent. If they do not have the requisite capacity, then we may impose decisions on them based on their best interests. And again, we need to be crystal clear about that. I'm not going to give you a lecture about the Mental Capacity Act, but I am going to say this. Can I beg you, as I beg every person involved in this area, not to talk about people who have capacity and people who do not have capacity. No such person exists. Capacity is decision specific and it is time specific. A person may not have capacity today to make a decision which they would have capacity in a month's time when they're in a slightly better place. A person may not have capacity to make a particular decision today, but can make plenty of other decisions today with capacity. And we simply need endlessly to remind ourselves that capacity is time and decision specific. And if we did that, I think we would avoid getting ourselves into quite a lot of problems, including myself, in an example I will mention in just a moment. So, what I want to press home is the fact that if a person has capacity, then they may make unwise and foolish decisions about which we are powerless, because the responsibility for the decision does not belong to us, it belongs to them. 3 quick examples. 10 o'clock on a Sunday night, I was at home, minding my own business, but the High Court judge on call. Telephone call from hospital, consultant in A&E saying we have an elderly gentleman in his 80s who has attempted to commit suicide by taking pills. He hasn't taken quite enough. We need to wash him out or he will die, but he won't let us anywhere near him. What are we to do? And of course the issue is, does he have capacity to make the decision to refuse? That's the only decision with which I am immediately concerned. There is a presumption that he does have capacity, so what is the evidence that he doesn't? Has a psychiatrist seen him? Yes, what did the psychiatrist say? The psychiatrist says that if he has to say he has capacity, he's not prepared to say it, and if he has to say he hasn't got capacity, he's not prepared to say that either. Well, of course, the interesting thing about that was that it brings the presumption about capacity to the fore, does it not? Mercifully, the man's eldest son was in hospital, a man in his 60s, who was happy to have a conversation with me on the telephone. And he said, we all deeply disapprove of what our father is doing, but he knows exactly what he's doing. Our mother died 2 months ago, and all he's talked about ever since is wanting to be with her. He knew just what he was doing. So I concluded that he had capacity. And I said to the medics, I'm very sorry, you can't treat him. And, you know, I got the phone call the next day saying, you may be interested to know Mr. A died at 3 o'clock this morning. Actually, this is quite tough stuff for people who have protective instincts and desire other people's best interests, to stand by and watch what we would regard as a foolish decision being carried through. So there's a lady with serious disabilities who is the subject of local authority care, not residential care, but local authority owe her lots of duties. She decides she's had enough, and she has bought a single ticket to Zurich to go to Dignitas. And the local authority come to the court and say, what are we supposed to do? And of course the only issue is capacity. If she has capacity, and the evidence was that she did have capacity, then the responsibility was entirely hers. And it was not for us to attempt to interfere with it other than by persuasion. So that if the law gives us power, it's because we have responsibility for the decision. If we do not have responsibility for the decision, the law does not give us any power. And so consequently, I had no responsibility for either of those decisions. Therefore, I had no power to intervene. And I have to tell you, those cases live with me as though they were yesterday, because I have deeply protective instincts and a desire to advance people's best interests, and I've had to stand by helplessly and watch. The third case was a lady who decided, who was subject to local authority care, but she decided that she wanted to strike up a relationship with a man who was serving 13 years for the abuse of his previous wives. And that was fine for as long as he was in prison. That was all capable of being restrained. It was all right for as long as he was on licence, on release from prison. But of course the time was coming when he wouldn't be on licence, and she was determined to maintain this relationship. And I, along with the local authority and the Court of Protection, devised what I thought was quite a good protective scheme to ensure, because we couldn't stop her having this relationship, quite a good protective scheme to protect her as best we could. In fact, the Court of Appeal said, very well done, but you fell at the first hurdle, because actually she had capacity to make this decision, and therefore you had no business imposing any protective plan on her at all. The question of capacity hadn't actually been argued in front of me. Somebody thought about it subsequently. But there we are. It was just a classic illustration. And the Court of Appeal, at the end of their judgment, said, all we can do is hope for the best, that nothing horrible will happen. Well, I don't need to tell you what that feeling is like. So we just need to grasp that there are circumstances in which we do not have responsibility, therefore we do not have power, therefore we cannot intervene other than by using persuasion. And we have to recognise that there are people who will have a different view of their own best interests to the view we might have, but who are entitled to pursue their own line because they have the requisite capacity to do so. And I raise it because it is, I suspect you, like me, do have strong protective instincts, do like to see people flourish as best they can. And it is hugely difficult, and it is therefore hugely tempting to use a power that you don't in fact have. And the Mental Capacity Act says you may not infer the lack of capacity from the desire to take a foolish decision. It would have been very tempting with the man in hospital or the lady who wants to go to Dignitas to say, well, perhaps they haven't really got capacity. But we actually have to be upfront about this in terms of capacity. human rights requires us to respect capacity. Human rights can sometimes be mighty tough, and the price of upholding human rights can be extremely high sometimes. And we simply have to be able to recognise it and deal with it. And I mention that because it seems to me that's an important one half of the equation. Okay, let's assume then that we're dealing with people who lack capacity, and therefore we have to act in their best interests. And of course, any of you here who practice in this area will go to sleep dreaming of Section 4 of the Mental Capacity Act every night, which sets out the basis on which we deal with best interests. All 11 subsections of it, a huge complicated list of things you have to take into account. But have you noticed just this? Section 4 is not exhaustive. It does not define everything that you have to take into account. Section 4 offers no hierarchy of values at all. There is nothing in Section 4 that tells you that one consideration is more important than any other. Section 4 does not define best interests. Indeed, nobody has ever defined best interests. Parliament won't do it, and the appellate courts, however much you ask them, will not do it, and say in terms that they will not do it, because they say best interest is so fact sensitive that the moment you start trying to draw definitions, all you're doing is creating a lawyer's playground for people to pick up distinctions and so forth. And there's a point, there's a reasonable point there. So best interest is not defined, it's not exhaustive, it doesn't set out any hierarchy of values, and it most certainly doesn't offer any answers. So it does provide a framework, but it leaves enormous discretionary powers to those who actually have to make best interest judgments based on Section 4. And if you want to know how wide Section 4 actually is, you make a little comparison between subsection 2, the person making the determination must consider all the relevant circumstances, and section 411, which helpfully defines relevant circumstances in this way. Relevant circumstances are those of which the person making the determination is aware and which it would be reasonable to regard as relevant. In other words, it's complete open shooting season. And it does mean that very serious responsibilities are imposed on those who are going to make best interest judgments and best interest decisions because of the breadth of the best interest concept. It's again a classic illustration. The state gives power, but it also confers responsibility at the time that it does so. And it's sometimes quite difficult to define precisely what the responsibility is under best interests. Let me give you an example. When you make a best interest judgment, what are you trying to do? Are you trying to protect the person, or are you trying to promote their autonomy? And actually those two things frequently pull in opposite directions. And you have within the whole complex of best interest determinations to make yet another rather subtler judgment. What am I actually trying to do in this case? Am I trying to protect, or am I trying to promote autonomy? The cultural shift, supported I think by the way the Court of Appeal is construing Section 4, is that there will be a weighting towards autonomy, but not at the price of abandoning protection. And there are therefore sometimes quite difficult choices to be made, and I'll give you an example or two in a moment to show you how that might work, and we need to be aware of that. But there is also mixed up in this little conundrum another subtle paradox which we have to resolve. Am I trying to protect a person's physical well-being, Or am I trying to promote their emotional well-being? The answer is I'm trying to do both, but frequently, again, I have to make choices. Now, in the statutory sector, people tend to err on the side of physical protection because it is measurable and because if it goes wrong, it's blindingly obviously gone wrong. Emotional welfare is not easily measurable, and if it goes wrong, it's not easily discernible, and it's very difficult to bring anyone to account over it. And therefore there is a tendency to promote physical protection at the expense of emotional welfare. And this comes down to the fundamental issue of the management of risk. We live in a risk-averse society. I do not blame anybody who is risk-averse in the society in which we live, where if something goes wrong, somebody must have been to blame, probably a professional. So of course people are going to be risk-averse. One of the reasons I've always encouraged people to feel free to use the courts is that the judge is actually infinitely better protected than anybody else in relation to risk. Why? Because I act in public, I give public reasons for what I've done, and I articulate the risk in public and why I've taken it. You can't do any of those things because of confidentiality. So if it blows up, everybody knows why it's blown up. High Court judges can only be sacked by an address of both Houses of Parliament, and you'll understand they're too busy to be thinking about that. And actually, no High Court judge has been sacked since 1689. So we are remarkably well protected. It doesn't matter what the Daily Mail says about us, as every sort of people. We are very well protected. So, of course, it's easier for me to talk about risk and practice it than it is for you. I appreciate that. But nevertheless, we can't escape it. Let me give you, if I may, just 3 examples to show you how this might work in practice, or has worked in practice. The first one comes from Liverpool, this was a classic case of just how things spring up on you. I was trying a long case in Carlisle at the time, and I had a spare day, and I happened to live in Liverpool, so they said, well, would you mind sitting in Liverpool for the day? So I said, no, of course I'll sit in Liverpool for the day. And a court protection case comes in front of me, and it's a man in his 80s who has basically destroyed his brain with drink and just about functions. He lived with, in a rather strange setup, with an elderly widow and her single son, and it was a fairly eccentric household, shall we put it like that. Finally, he became very ill and was admitted to hospital, recovered from that. They wanted to discharge him, and the issue was, where was he discharged to? Every professional said he was going to an EMI, that's where he will be nicely looked after, all the rest of it. He and the elderly widow said, no, we want him back home with us. And that was the issue. And council got up and they said, well, you know, we need 5 days to determine this. And I said, you've got 1. What are we going to do? And of course, when it's put like that, they suddenly discover they can do it in 1 day. And we duly did. But you can see, can't you, the issues there. Protection against autonomy, physical welfare against emotional welfare. How do you balance those things up? Of course, if he went into the EMI, he would be safe. He would probably be physically well cared for. There was no reason to think he wouldn't be. If he went home, he would be at risk of squalor, and he would be at risk of perhaps, you know, less than adequate physical care. But that was where he belonged. That's what he saw as his home. They saw it as his home. That's where he wanted to spend his last years. And so there was that tension. How do you resolve it? Well, as I say, every professional said EMI, except the judge who said, no, he's going home. Why? Because I chose to promote emotional welfare over physical well-being. And of course, all the authorities were perfectly happy with that because I had taken the responsibility. If this all went wrong, it wasn't down to them, it was down to me. Now, I'm told, I don't know, I'm told by casual conversation in the coffee house that actually it worked quite well, but I don't actually know that as a fact. So that's one of the kind of examples, and you'll relate to that fairly readily, I expect. The second one was not dissimilar, but it was a London case, in which two cousins had been living together. One was rather older than the other. And frankly, theirs was a less than adequate bachelor household, shall we put it like that, in which the local authority had wanted to be involved and on which they had very firmly closed the door. Finally, one of them had to be admitted to hospital, and he recovered, and the same problem arose. Where do they go? Now, in this case, it has to be said that going back to the cousin was to invite all sorts of risks, and that the person would actually be much better off in a care home. But of course, there was no way they were going to accept that. But they were going to accept that local authority might have a bit more involvement in their home. Now, it seemed to me that actually the placement at home was never going to work for any length of time. Nevertheless, I sanctioned it for two reasons. One, because emotionally it seemed hugely important, and secondly, because this man would never settle in a care home until he had discovered for himself that placement with his cousin really, really wouldn't work, and then he might have a much better chance of settling. Again, you know, judges can take those kind of risks, and I deeply sympathise with professionals who feel they can't, for reasons that you will only too readily understand. The third case was slightly more dramatic, and it involved a young woman from an ethnic minority who lived in a relatively chaotic home. She had quite significant learning disabilities of her own, and she got herself pregnant. It was crystal clear, A, that she couldn't manage any child, and B, that her family couldn't either. And so the professional view was that her best interest would be served by her having an abortion. And she didn't want one. Now, how do you resolve that kind of issue? Because, I mean, the idea of imposing an unwanted abortion is, I think, stretching ethical concepts to their extreme, however much it might be in the best interests of the mother. In fact, the problem resolved itself because the evidence indicated that the woman, for all her deficiencies, had capacity to make that particular decision at the time we were talking about, but she had lots of help in terms of thinking it through and articulating it. So, of course, the problem resolved itself because there would be no abortion because she had capacity and was refusing. But you can see where that might have gone to in terms of a sort of classic in extremis argument between emotional and physical welfare, between protection and promoting autonomy. So I really wanted to offer you those thoughts as we reflect on the fact that we need to be careful not only about the powers that we have if we are exercising state powers, but also to be very conscious of the limit of our responsibilities. I actually think that very often we take on more responsibility than in fact we're required to do. And that blurs the line sometimes between the right of individuals to make their own decisions and the obligations of the state to protect them. We simply do not live in a world in which everybody is going to do what we think is best for them. Now, of course, I might like to live in a world where everybody did what I thought was best for them, but we don't actually want to live in any such world at all. But the reality is, if we don't live in that kind of world, there are times when the rest of us have to stand by and say, this decision, however much I deeply disapprove of it, however unhappy I am about it, however miserable it is to stand by and watch a completely unnecessary waste of human life or energy, their responsibility for the decision is not mine. and therefore I have no power to intervene. If of course I have power to intervene, then I have a responsibility, and we're back to the best interest, we're back to tensions between autonomy and protection, and I do think we need to be aware of those and articulate them, and we're also back to these subtle differences between emotional welfare and physical welfare. They're all legitimate concerns. They all have to be taken into account. It's just that they often lead to very different results, depending on where you make your choices and why you make your choices. And so I simply want to alert you to that. I'm sure you know it, in fact, but I wanted to alert you to it in terms of how it actually works out in practice. I'm going to stop now, not least because you've patiently listened for half an hour, and that's more than anybody should be asked to do. I'm going to stop now. That'll leave us a few minutes for any questions if people would like to ask them, and then we can come back later on if you want to. Thank you very much. Thank you very much, Mark. Yes, we do have some time for questions if anyone wants to.
Hi, good morning. Thank you very much. My name is Noida Nator. I'm a designated safeguarding adult for one of the emergency CCGs. I think, in terms of mental capacity, thank you very much for this update. Very, very informative. I think probably the difficulty that we do have, especially for people who seemingly have mental capacity, we've seen that in a lot of these safeguarding adult reviews, whereby the person apparently has got capacity and the nurses have gone to see them, despite lots of information about, let's say, the pressure sores, they refuse to be seen by professionals. They said, no, I understand, I'm okay, I got pressure ulcers, I can deal with it. But time and time again, when people go, it's the same thing, and the person found postmortem dead because of multiple grade 4 pressure ulcers. Now, we know that following the investigations and the SAR reviews and the whole thing, it's about how do professionals, even though they have had the risk assessment, they've got the managers, multidisciplinary meetings, there is always, people keep on saying, no, it's not about blaming, but people have been either disciplined for not doing whatever, for doing whatever they could do, but the responsibility, like you said earlier, I think for me, yes, how much we can do, we don't, there are times when we can say, look, it's not our responsibility. So I think sometimes people do get blamed, and organisations do get blamed for not actually do more proactive work.
Thank you. I entirely accept that. Two comments. One is, of course, it is an indication of the importance of recording why you don't do something, as well as recording why you do something, so that at least you've got that down. The second thing is that sometimes we're a little too easy about capacity. So, you say the person has capacity when they have chronic bed sores. Let me just give you an example. I remember being rung up by a consultant one day of a woman in her 20s who had no history of mental health, mental capacity or anything at all, who suddenly in the course of labour and in the course of delivery refused all treatment. And on the face of it, she was a person who had capacity. The consequence of refusing treatment was that she and her baby were liable to die. And they said, what do we do? And I said, well, obviously it's a capacity issue. Have you explained to her what the consequences are? Yes. What was her response? I don't want to die. Therefore, she is completely unable to weigh up the information she has got. Therefore, for that particular moment and that particular decision, she doesn't have capacity and I can intervene. I think sometimes, you take your bed sores issue, for example. Now, if a person sits there saying, I've got bed sores, I know I've got bed sores, they're going to get worse, it's all going to be very terrible, go away. I agree, there's not much you can do. But actually, if you press, you may find that actually that's not the outcome they want. And you may therefore find yourself in a position of saying, in relation to that particular decision at this particular moment, that person lacks capacity and I'm going to intervene. And I think that's the other side of the business about capacity being time and decision specific. We tend to assume that if a person has capacity to make all sorts of big decisions, they've got capacity to make all decisions. Not so. I have he doesn't mind my saying this because I hawk him around on a regular basis. I have a very disabled youngest son who falls in that interesting category of, because he has good command of language, of appearing much more able than he is. So people make assumptions about his capacity, which is simply not founded. I remember having a big argument with the landlord who wanted him to sign the tenancy agreement. And my saying, actually, of course he's got the capacity to decide what curtains he wants, and whether he wants to live here, and you know, all that kind of thing. But in relation to a tenancy agreement, I don't think he has, because I don't think he understands the issue of what the consequences are of not paying rent, because he won't have to pay, because it's automatically deducted and so on. And in the end, they agreed, and you know, they had the standard license for which was signed. So I think we kind of need to be careful about general assumptions about capacity. It needs to be addressed in relation to the particular situation you confront and resolved accordingly and recorded. Very important, that, isn't it? Yeah, thank you. Sorry, yes.
So Walter Lloyd-Smith from Norfolk Settlement and Oxford. Thank you very much. Really interesting, quick resume. I'd be just interested to invite you to give a few comments around the issues of coercive and controlling behaviour as it interplays around capacity decisions which are very time specific.
Capacity requires that you can receive information, you can weigh information implicitly free of coercion. So if there are coercive forces at work which impact on that decision at the time it's being made, then that may raise questions about capacity. The difficulty is you may be dealing with someone who already has quite enough to put up with without officials coming along and saying you haven't got capacity and we're going to take over what happens. And I can understand there will sometimes be a reluctance, as it were, to add to a person's burdens. But I think the reality is, in coercive situations, you are applying the Section 3 test, and you are asking whether they are giving free consents to what is going on or not. And I'm not sure I can help you more than that. I mean, I actually just think it's a judgment you have to make at the time. Part of the trouble with all this stuff is that although the law is relatively easy to articulate, it is astonishingly difficult to apply because human beings are a perverse lot. And not only are we a perverse lot, we are all different. Therefore, every set of circumstances you confront is in itself unique. It may have common trends, but it will be unique because of the particular individuals involved. That's both yourself and the person you're dealing with. You're both unique individuals. And so it's very difficult to lay down desperately precise approaches. You just have to be aware of the risks of coercion, and they get very subtle. I mean, I just had to deal in clergy discipline with the whole issue about what is spiritual abuse. Well, you tell me what spiritual abuse is, but it's rather like the elephant in the room. It's extremely difficult to describe, but you know it when you see it. And there are circumstances in which you find yourself in exactly that position. You kind of, you know it when you see it, although it's actually quite hard to pin it down. That's not terribly helpful, but I think that's where we are in reality. Sorry?
There's a question about Pete Morgan, I'm a consultant. I just wondered what thoughts were, because you use both terms today, and lots of people use it, the difference between a presumption of capacity and an assumption of capacity. Because there's two different words.
There is a difference.
And how that fits in with 211 of the Code of Practice,
Right.
which actually suggests that repeated unwise decisions is a reason, not for saying somebody hasn't got capacity, but actually examining whether they have.
Yeah. The difficulty is that people who lack capacity may make unwise decisions. It's just that you can't turn the argument the other way around. The presumption is, when I use the word presumption, that is a legal term. The statute requires you to presume capacity unless you're satisfied to the contrary. I think when I use the word assumption, I think I'm talking about our general reaction when we meet someone, and that you assume they have capacity because they can make lots of decisions, and forget to ask yourself whether in the particular circumstances they have capacity at the moment to make that decision. So presumption, I've got a legal hat on. Assumption, I'm merely wearing human clothing. I think it's probably, in terms of the way I use the words, I think that is the difference. Presumption is something you think about. Assumption is something almost by definition that you don't think about. You just find yourself in that position until you challenge it.
It seems to me at times people assume capacity without doing that questioning on.
Exactly.
Which doesn't actually show us
it's
not being aware of the full consequences of that. And when having that explained to us
yeah.
is different. But it just seems to me that there is at times professionals actually run away from asking the additional questions and are going to presume on the basis of knowledge, have to assume on the fact that you're a human being, therefore I assume you have capacity.
And also, people sometimes assume incapacity from all the other attributes of that particular person without asking whether in relation to this decision they have capacity. So, you know, this is absolutely classic with people who are descending the dementia scale. Because it's not a steady down, it's a sort of, and indeed it has some ups. People may have decisions that, you know, I remember doing a case in which a man in his 80s who was very wealthy and had a lot of money, and children were rather aware of the fact he had a lot of money, decided he wanted to marry his carer. And there was a certain amount of excitement in the family. As a result, this is in the law report, so I'm not breaching any confidences. And of course the issue was that he had capacity to decide to marry. He might have capacity from time to time to change his powers of attorney or alter his will. He didn't have capacity to manage his overall affairs. So we had capacity, no capacity, and varying capacity, all in the same case, in the same set of facts. And you just have to be aware that in the real world of human beings, you do encounter that. And you have to ask your question at each stage in relation to each decision.
Thank you. I think we've
run out of time.
Yes. Thank you very much.
Thank you for inviting us. My name is Paul Kingston. I'm going to talk about the work that I've been doing with my colleague Luke.
I'm Luke Joannou. I'm General Counsel of the Royal British Legion. For those of you who don't really understand what General Counsel is, I am effectively Director of Legal for the Royal British Legion.
So we're going to talk about the situation, as we understand it, with the charity sector at the moment. So I'm going to do a bit of an overview in terms of how I think we've reached this situation that I described as safeguarding competence in charities and a panic of safeguarding diligence. And then Luke's going to talk about, are you struggling to hear me? Okay, so then, is it better to use that? Red button. I'll try my best to speak up now. I'm going to talk about, I think, what's happening in terms of the present position in terms of the charity sector and this concept of safeguarding competence. And then Luke and I are going to tie up with what the Royal British Legion's been trying to do in terms of its addressing this particular situation. And that's where we want to go. But essentially, this is work in progress. So we would really value your observations and questions in terms of, are we moving in the right direction in terms of the work that we've been doing. So to start with, I mean, the situation is that whilst there is coverage in the media, consistent coverage in the media about safeguarding in the charity sector, if you actually seek empirical evidence of the challenge and the size of the problem, there isn't much empirical evidence. It's not really out there. You rely on Daily Mail and other newspapers telling you about particular issues, particular situations, for example, Oxfam, which I'll mention in a few minutes. But the evidence in terms of the scale is not out there. And if we don't have evidence of the scale, I would argue we've got even little insight into the challenge that this sector is facing at the present time. Just how does the third sector charity situation develop their competence, their diligence in terms of safeguarding? So I'll do a quick tour of this panic situation as I describe it. I use the term panic in the sense that we've got a panic in the media, but I do think that the third sector is aware of this situation and is addressing it. Some organisations, I would say, perhaps quicker than others, but there is no doubt that the organisations I've been working with over the last 12 months clearly know that they have a task in hand, which is a considerable task for many, but some organisations who've moved very, very quickly in terms of their safeguarding competence. Luke's going to talk about how the RBL has developed its response to this particular challenge. But the other issue I'd like to raise to start with is the fact that I think this is a real opportunity for experts in the public sector and the academic sector to actually help the third sector. Because what seems to be happening is lots of the charities are seeking advice on safeguarding from the audit section of communities. So auditors now are asking charities when they're going to do their fiscal audit, are you competent with safeguarding? I'm not so sure that that is a sector of intelligence that understands exactly what safeguarding is. So it seems to me that we can offer quite a good service to that third sector in terms of our expertise with safeguarding. And obviously the Royal British Legion has done that because they've pulled in people from the safeguarding sector to help with them, as opposed to pulling people in from the audit sector and accountancy. This is just I just wanted to point out here that we've had, over the last 20, 30 years, we've had scandals in the NHS, we've had scandals in primary care, we've had scandals in hospitals, in private hospitals, in independent hospitals. We've had individuals in terms of King Savile who've really been involved in tremendously abusive behaviours. And it's gone on and on and on, and you can see it through the newspapers. But the complexity of what we're dealing with has also increased, as you very much know. And when I started to become interested in safeguarding 20 years ago, we didn't have this list. We certainly didn't have modern-day slavery. We didn't have people trafficking. We did have self-neglect, although it wasn't really considered up until the Care Act as necessarily fitting under the jurisdiction of safeguarding. But now we've got other issues in terms of prevent and challenge. So the complexity of what we know we have to deal with in the public sector is expanding. But at the same time, the third sector, in terms of the charity sector, is asking these same questions and saying, my goodness, this is just a huge menu that we have to deal with. And then we have Oxfam. And as soon as Oxfam arrived, I think the charity sector suddenly really did internally reflect and ask itself, so what are we doing in terms of our own safeguarding competence? But it's interesting to know that if you do try and find a literature that precedes Oxfam, I came across this particular quote, the National Crime Investigation Service, saying that increasing numbers of paedophiles were focusing on charities or teaching work. NCS knows of paedophiles who have pretended to work for charities and who've invented charities in foreign countries. These pretend charities are in effect nothing more than paedophile rings. Now, if I was suggesting that would have been in the newspaper around the time of Oxfam, you wouldn't have been surprised, but any idea when it was actually in the newspaper? You probably can't see the fine print, but this was the 22nd of July 1999. So it's not, in a sense, it's not a new phenomenon. Essentially, what Oxfam did was put it absolutely front centre stage in terms of the third sector, the charity sector. But there's been rumblings for a long time. It's only just recently, I think, that with the red headlines of Oxfam, that the sector's suddenly starting to take heed. And of course, the Charity Commission as well have been aware of that particular quote going way back to 1999. And you can see the references to this. Interestingly, as soon as Oxfam did expose that behaviour in Haiti, ASIVO immediately called for a centre of excellence for charity safeguarding. I don't know where the conversations are in terms of this centre for excellence for charity safeguarding, but I certainly think there's a demand for expertise that sector is definitely looking for at this point in time. But at the moment, it's predominantly being offered by, as I say, by the audit section of legal or audit companies. We will say more about this, but one of the things that we certainly had to do at the Royal British Legion is ask ourselves, what is this going to cost to become competent as a charity? The RBL is large, Luke will tell you more about that. But I found some figures which suggest that perhaps for a charity that's got income of several millions, this is a possibility of investing. But for small charities, perhaps this is going to become an issue that is going to really stretch them in terms of their income. And perhaps they won't be able to do it alone. Perhaps they'll have to consider consortium, small charities getting together to seek advice and become competent through a consortium. But there's definitely going to be a cost. And of course, the Charity Commission itself has found itself wanting in terms of its scope and its size. They're now talking about the possibility of recruiting 85 new staff just to stand still in terms of where they are with safeguarding. I don't know where the money will come from for those 85 new staff, but it's because of post-Oxfam there's been a spike in cases that have been alerted to the Charity Commission. Another interesting question which we'll mention of how we've addressed this at RBL is a question about should there be safeguarding expertise on charity boards. I would argue that absolutely there should be safeguarding expertise in charity boards. If you look at the NHS, if you look at non-executive directors, there is pretty much always a non-executive director on an NHS management board with a safeguarding portfolio. I don't see why that should be different in the charity sector. I'll whiz over this cyber security issue, but just to say that we must be aware of the growing issue of cyber crime and of the damage that social media and financial crime is causing. I think we've certainly, I'm aware, I've been doing some research on the impact and health impact of scams on older people, and I think we've, in a sense, we've kept our eye off the financial abuse situation to the detriment of lots of people who are consistently being financially abused, not necessarily by families, but by strangers online. We're missing that one, I think, in a big way. And of course, if you have charities that have got literally hundreds or thousands of recipients, I wonder if we're actually asking that question about are you financially safe? But the real issue that I came across when I was asked by Luke to start to help them with safeguarding was to try and balance, and it resonates with Sir Mark's issues about this balance between different responsibilities. Because the charities have a responsibility to safeguard the public, the recipients that they help. But the Charity Commission also argues that they have the duty to organise, that the organisation's workforce needs to be protected, and also the organisation itself needs to be protected. That causes and I would argue internal tensions. So I've said there are inherent ethical tensions here, because by safeguarding the public, the organisation may be exposed to external criticisms and penalties from the Charity Commission, media exposure, etc. Conversely, if you safeguard the organisation, then you're in the same bind in a sense. And I would argue we're Oxfam exposed to this conundrum. It's a really difficult balance, and I think what happened with Oxfam was that they were less than transparent when they did discover that there were issues within their organisation. Just to try and tie up before I open to Luke, if you look at some of the only research I did come across in terms of slightly giving an illuminated insight into the charity section, there's some interesting data that's coming out now that's arguing that since Oxfam, well, actually since 2014, actually pre-Oxfam, certainly the public trust in the charity sector is going down. It's gone down consistently from 2016, and it's gone down again in 2018, compared with the level of public trust from 2005 to 2014. So the public are starting to ask questions, definitely ask questions about whether they trust this sector consistently more than they perhaps did 5 or 6 years ago. There's a really useful document called Taking on Trust that's been produced, which asks questions about the awareness and effectiveness of charity trustees in England and Wales. Essentially, this piece of research is asking charities, how effective do you think your governance is for trustees? And there are some really interesting questions about safeguarding. So you can, safeguarding is at the bottom of the middle section there in terms of service delivery skills. So this table is asking, are trustee skills represented on the board? And the trustees that responded to this questionnaire, it was a huge sample actually. I think it was over 20,000 trustees responded to this sample. 42% said that there were sufficient skills on the board in terms of safeguarding. Actually, I was quite surprised at that, because I thought that was perhaps slightly over-optimistic in terms of this sector. And they then asked the questions about safeguarding. This is looking at the different size of charities. The top line is a 5 million plus, and the bottom line is charities with income less than 10,000. And it sort of looks as though generally across the board, whether you're a big charity, whether you're a small charity, that there is sufficient safeguarding skills represented on the board, which again is positive. But if you then start to look at the different rates of where they ask these trustees, in terms of rank order, in terms of different responsibilities by board members, where would you rate safeguarding? You see, this is what you see. You see that actually the bigger the charity, the lower down the importance safeguarding comes. And the bigger charities, the 5 million plus charities, rated in 8th in terms of issues for governance, compared with 4th for small charities. The argument is that the smaller charities perhaps are far more, they're closer to the community, and they're pretty much all their services are delivered in the communities, whereas the larger charities may have a more wider portfolio, or public engagement, position statementing, etc. But it is interesting that even though 42% claim that they have competence on the board, they go down to 8th for the 5 million plus charities. So I'm just going to finish my section by arguing that I think certainly for the charities, it seems to me that there are some serious issues that need to be addressed. And the first one is the complication of a charity that I would argue delivers what I describe as quasi-social work, but it's not classed as regulated activity. This for me is one of the big issues for the large charities. So for example, the RBL does provide lots of client-oriented care that I would describe as quasi-social work. They're not qualified social workers, but they do make assessments of people's needs, and they do provide, or they certainly act as a liaison to finding resource for those individual needs. And yet, it's not regulated activity. So, does it fit under the jurisdiction of DBS is an interesting question. How do you safeguard an organisation through the DBS where perhaps in some parts of the DBS system they will say, you can't actually come to us for a check because it's not regulated activity. And we do seem to have a difference of opinion between England, Scotland and Northern Ireland as well in terms of what they would consider to be appropriate for a disclosure check. The third one is this issue about safeguarding recipients when providing services outside the UK. It's challenging enough to have an architecture in the UK for a large charity. How do you provide reassurance that you're providing a safe service in Haiti, in many countries in the Far East, for example? In Europe, perhaps it's easier. We know that safeguarding is developed across Europe, but certainly when you go further afield into developing countries, it's immensely difficult if you've got, and the RBL, of course, covers, I think, 60 different countries. How do we reassure ourselves that we're safe in those 60 countries? What are the responsibilities of safeguarding when a charity has members? The RBL has members. So how do we deal with a member who perhaps behaves in a way that we wouldn't want them to? What regulations do we have to say we don't want you as a member? Do we have rules that can say we don't want you as a member? You're a card-carrying person of the RBL and you've done something that could put us into disrepute, but what can we do as an organisation in those circumstances? What are the responsibilities for volunteers? Again, the RBL has thousands of volunteers. You will see them on the streets in the next few weeks as poppy collectors. Again, how do we safeguard that organisation with the volunteer population? And the one at the bottom there, which constantly challenges me, is what are the responsibilities of a charity that procures services, offers grants, and administers monies on a regular basis? Money pours out of the RBL on a consistent basis, day after day. How do we make sure it's going to appropriate individuals or appropriate organisations? And how do we make sure that's safe? How to scope and develop an integrated DBS system for a big organisation like the RBL. It's okay, we can develop a system for new employees, but how do we develop a system for existing employees? 1,600 employees in the RBL, and suddenly we've got to a situation where we've now got to say, well, actually, we didn't think when we first employed you that you needed a DBL check, but maybe you do now. So that's an HR issue that all charities will have to face in the future. How to develop integrated information systems as well. We've got risk systems in most charities, but whether we've got safeguarding risk systems is a different question. The challenge of training a workforce, again, training 1,600 people, that is going to cost an enormous amount. The RBL is committed to do that, and it can afford to do that. Can a charity with an income of £10,000 or £25,000 afford to do that? How will they train their staff? And you've got the challenge of training the workforce at different levels of the organisation in different geographies and even in different countries as well. I mentioned safeguarding in Scotland, Wales, Northern Ireland has slightly different jurisdictions, and of course the DBS system is different, so we're having to negotiate that at the same time. And how do you set up a safeguarding workforce in a very short time limited period in a charity? So the RBL now has a head of safeguarding, and we have leads in all the regions, but that's only happened in the last 12 months. But it's taken resource, and again I would argue the RBL is in a position because of its size and its income to be able to do so. Will smaller charities be able to do so in the future? So that's my overview, and I'll leave it now to Luke to talk.
Thank you. I've given you my email address and my telephone number, so if you do have any questions to ask, please do feel free to contact me. Context. The Royal British Legion is a large charity. Our income is around £150 million per annum. We spend about £150 million per annum as well. We have beneficiaries to the tune of about potentially 5 million people, not only in England, Wales, Scotland, Northern Ireland, Republic of Ireland, but also around the world. We have about 230,000 card-carrying members, and we have, I think, probably the largest volunteer network for any charity in the whole of the UK. Roughly 130,000 to 200,000 volunteers will be deployed on the streets of the whole of England and parts of the world over the next 5 to 6 weeks. So we're quite a complex organisation, and I thought it would be useful for me to just sort of put into context why we as an organisation took safeguarding really seriously. So part and parcel of my role is not just being responsible for legal, but I'm also responsible for risk management. We've heard talk about risk management, undertaking risk assessments. One of the things that I noticed when I joined the organisation was that safeguarding was a perpetual thing that kept on coming through on risk registers from the different parts of the organisation. And it seemed to me that the risk management elements of safeguarding was dispersed around the organisation. We had effectively a director of HR who was responsible for safeguarding, but then as the directors of HR moved along, we found that it was beginning to sort of fall in between the cracks. So way before Oxfam started, in June last year, we decided to go and embark on a journey to look at our safeguarding framework in its entirety, a root and branch review of safeguarding. Now, we did actually go to an external auditor to help us out with this, but it wasn't really for them to tell us how to do safeguarding. I wanted them to do an in-depth look under the bonnet and assess where our gaps were, look at exactly how we did safeguarding, and to basically analyse where we had problems. So that journey started off in about May, June last year. We had the report from the auditors, and then we started to embark on looking at each and every component of the analysis that they had undertaken to make sure that we had actually reached the gaps that they were identifying for us. And then you start to look at the context of the wider charity community. We started to get rumblings of issues coming through from Save the Children, from Oxfam, the old Vic, for example. And we actually thought this is a really serious issue that has to be dealt with. One of the things that we wanted to make sure that we didn't do was to conflate the legal responsibilities of safeguarding, and that is looking at the external environment. You've heard Paul talk about the tensions that are involved. The external environment is that we are looking after vulnerable adults and occasionally vulnerable children. We mustn't conflate that with the issues about looking after our own staff. We do have to look after our own staff. That's an HR issue, that's a health and safety issue. But when it comes down to the safeguarding framework, the legal framework is looking after vulnerable individuals outside of your organisation. So when we went through the whole of the audit process, we understood exactly where our policies lay, what the gaps were in our policies, and then we wanted to go through plugging all those gaps. And we as an organisation agreed at the very early outset that this was a serious matter. We could not just pay lip service to plugging the issue of safeguarding. Executive Board of the Legion took it very, very seriously. Our trustees took it very, very seriously, and we agreed at that moment in time to go on a journey to make sure that our organisation was fully safeguard compliant. I think we're getting to that position now, and we are looking and we use experts in the field to ensure that they provide us with a check and a balance to see that we are going down the route of making sure that we are compliant. So, to do it correctly in an organisation, I think you have to advocate and really press forward a cultural change in the organisation. It is not just about making sure that you have vulnerable adults looked after and vulnerable children looked after, but the whole of the organisation has to be acutely aware of situations where problems could occur and where you have to deal with it. And there has to be an openness from the organisation to speak up. Far too often we have seen over the years where things have actually been swept under the carpet in any organisation. These are the sorts of things that came through with the Savile inquiry, with Rolf Harris. People were not speaking up, and now we are advocating a culture of people being able to speak openly and freely, to escalate issues to the organisation. People have spent a lot of money over the last year on making sure that they're GDPR compliant. Every single organisation has been doing it. But you should also, as an organisation, when you're looking after vulnerable people, make sure that you're safeguarding compliance as well. If you're going to spend money on GDPR compliance, spend money on making sure you're safeguarding compliance as well. And one of the key things is training. Training, 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 and more training. Look at your DBS processes. Make sure you get management buy-in from trustees as well. We have that. We have a safeguarding expert on our board of trustees now. We have an executive board director who is responsible for safeguarding, and basically that person will have their head on the block if things do not go correctly. They have a responsibility for making sure this is works. But one of the key fundamental things that I kept on, I presented to our executive board and also to our board of trustees. No matter how many elements of safeguarding process you put in place, you will never be able to completely and utterly ensure that an unscrupulous individual will not enter into your organisation. We have a situation in our organisation where we have 230,000 members. We do not vet each and every member. We have over 130,000 volunteers. They have an interaction with our beneficiary class. We go through the process of DBS checking them, but the DBS check is only as good as the last time it was checked. So in the intervening period, you could find an individual who is actually potentially a paedophile, and that has not come through. Or they have been found to be unscrupulous. They have been taking money away from elderly people. They've been stealing money, fraudulent. So you've got to just be very acutely aware that this is a constantly moving feast for your organisation, and you should not stand still. And then resource it properly. It does cost money to do things. You know, we, as an organisation, I think we have spent close to £250,000 on making sure that we get the safeguarding into a position which is getting better. We have agreed and have put aside budget to spend money on making sure that we do that. I thought it would be useful just to spend a few moments on talking about the what if it goes wrong. As a lawyer, I'm always looking at this. You know, we're trying constantly to look at that crystal ball and make sure that we try to put in place defences for our organisation. How do you deal with the safeguarding inquiry? I think fundamentally the most important thing is to take it really, really seriously from the very beginning. There's confidentiality that you have to apply to it. Make sure that the information is contained within the organisation. Make sure your senior executive board members, your trustees, understand that there is a situation going on. And there is a legal responsibility that you have in terms of safeguarding, and I think there's also the moral responsibility as well. And I think, say the Children Oxfam fell foul of the moral responsibility. They did everything, as far as I'm aware, legally correct. When they found out about the issues in Haiti, etc., they dealt with it legally responsibly. However, their executive board members, their chief executives, did not deal with it responsibly from a moral perspective. and hence have rolled as a consequence of that. And also, they have also suffered a downturn in their income streams as well. So Oxfam, I don't have the exact figures because their audited accounts haven't come out yet, but I know that their income stream went down. They've actually managed to stop that gap because they've had a huge £41 million inheritance legacy that they've received. But if you don't do safeguarding correctly, you get it wrong, it gets into the press, there will be a financial impact on your organisation. It has become very apparent that happens. There are legal requirements, obviously, as I've said. You've got to report this, you've got to tell the Charity Commission. There is the Serious Incident Reporting Mechanism. We have other regulators as well. We've got CQC that we have to report into. We have care homes. We look after lots of vulnerable people, as we mentioned before. And we have to make sure that we undertake our legal compliance properly and correctly. The Charity Commission has been inundated with serious incident reports over the last half a year. In fact, in the last 2 years, I think they have had more than 250,000 serious incident reports on safeguarding alone. That's a lot of incidents. And as I said, there are repercussions if you don't get it right. My role is to protect my organisation, not only to protect my chief executive, but also to protect my trustees. I do not want them appearing before a government select committee. So we talked about safeguarding the main elements of it, resourcing it properly, making sure that your policies are correct. I'm happy to talk to anybody about what we went through to make sure we got our safeguarding correct. I'm happy for anybody to plagiarise our policies as well, because there's no issue for me to actually say that, because I think in the sector we need to work together to make sure we get it correct. And that's it from me.
Thanks very much for that. We've got 5 minutes if anyone has questions of all Luke. Please.
Hello. My name's Andrew Burrows and I'm Head of Safeguarding at the Conservation Volunteers. And we've had much the same issues that you've been describing. All of our, what would be, I guess, beneficiaries are described as volunteers. They come to us, and we started off in the early 50s, it was all healthy students. Now the people who come to our open volunteering, to lay hedges or to do, deep canals, banks, are all over 50% people with a whole variety of needs. So learning disabled people, people with mental health problems, and they just come as an open. It's become, much of our service has become like a day centre without any of the other safeguards and provision. And so we've been putting in safeguarding elements over the past 2.5, 3 years, I guess. Our issue is that we just don't fit. We don't fit with DBS, we don't fit, particularly in Scotland, with the DBS process there. We were in Scotland, Northern Ireland, and it's, I guess my question is, how do we need some central direction really about this. We need, because we're always trying to balance obviously safety and proportionality here. We are a reasonable, a medium-sized charity, but how do you make it fit? And we need some sort of central direction. Do you think that's right?
Absolutely. I don't think lots of charities fit. That's what I discovered when I was asked to work with Luke. Particularly around the DBS, you're absolutely right. It just doesn't fit when you've got people who volunteer or you've got members. It certainly won't fit under the architecture of the statutory guidance we have, the Care Act and children's safeguarding. I think the only way it's going to fit is if the Charity Commission find a way to make it fit under their jurisdiction as safeguarding. But it certainly won't fit, I don't think, into the public sector jurisdiction that we have at the moment. It's just not working now when it comes to volunteers and members. And I don't know how it could fit actually in that at all. So we've got to go in another direction. The only direction I can see is we go to the Charity Commission and say, actually, you need to come up with some architecture of safeguarding through your regulation. I don't know if you agree with that.
Or the other, well, Yes and no. The Charity Commission doesn't have any money, so we've got to be realistic about it. Apparently they are going to recruit another 80 odd individuals to help out with safeguarding. Whether that really happens is a different matter, because employing 85 people when they've actually laid off more than 350 odd people over the last few years is going to be very difficult for them. I think it's pertinent upon the organisation that you're with to actually start putting in your own framework of safeguarding requirements. Yes. So whether or not the Charity Commission actually says do this, do that, or any other regulator says do this, do that, you've got to take it upon yourself to do it, because you're actually protecting your organisation. And it's a good risk management tool.
Julie Hall, Head of Adult Safeguarding NHS Luton CCG. I just wanted to know what links you had with the safeguarding adult boards or children's boards?
As a charity?
Yes.
There aren't any formal links. This is another issue, because we provide services across every single board in the UK, both adult and child. How you develop links, I have no idea. What we have done though is each region now has a safeguarding lead who is trying to link in their region with those safeguarding boards. But it's a tenuous link, in as much as all they can do is tell that board, I'm the safeguarding lead for this charity in your region, you know, and make sure that they've at least got phone numbers and quick access should they require assistance or guidance or, you know, communication line of inquiry. But to cover the geography, it's really challenging. It's really difficult. The only area where it works very effectively is where we've got care homes, and that's where we've got a really strong relationship with the boards. But we're out in the middle of, you know, Norfolk, where you've got, I don't know how many various local places, you know, sorry Bridget. There's so many recipients in that part of the country, it's really very difficult to connect to every single board, but we're doing the best we can through the regional network.
And it was a fundamental gap that we actually saw. So the care homes were quite well catered for, because they have a local community, they know who their safeguarding lead is. But in the dispersed community we couldn't manage that. So that's why we actually created the role of head of safeguarding. We actually needed to have that, because at least then we've got a focal point, a coordinator that can actually deal with all these issues now.
We have a couple of questions, I think 2 or 3 questions that are coming up. Don't forget we do have the discussion point. I'm going to keep us to just one, I think, now, and a short one if possible, Pete. And then save the questions, please, till the discussion time at 12:30 before lunch, if that's okay. Or grab people during the break. Pete, a quick one if you can.
Possibly. I think you said that 250,000 was to the charity commission. I just wonder how many of those, if they were actually safeguarding, went to the local authority safeguarding procedures, it was Swanton, if nothing else. And following on from that, I actually chair a safeguarding panel for our housing association. The one that I have is the mixed, putting it politely, response one gets from the local authority process. One refers things in, both in terms of time in which response comes back, the lack of response in some cases, and occasionally actually flat in the care act. Like not actually doing a song, you found somebody's dying, you actually come up with the concept of the fact that neglect is involved. I just wonder what your experience was of actually referring stuff through to the local authority procedures. This is not a quick one, sorry.
I can't speak for it. I can only say that we've got a system to do that. I'm not in a position quite at the moment. We'd have to talk to the head of safeguarding in the Royal British Legion to get a response in terms of how are your response, you know, what are you getting back from local boards when you do refer in. But I do understand that the second point you made is even when you do refer in, the threshold at which people are making Section 42 inquiry decisions now is so high, and the first question they ask is capacity. and they won't even get involved in many areas if there is an issue of capacity, which I don't understand really. I don't think that should be a triage question that you should ask when someone is referred into safeguarding. But that's my own experience from sitting on boards as well. I don't know if other people find that.
From the perspective of the Charity Commission, the Charity Commission are receiving many serious incident reports, and they are not able to respond back to them. They just do not have the physical capability to do that. One of the things that the Charity Commission is actually looking at, and there was a roundtable discussion earlier on in the summer, and they're continuing with those discussions now, is the possibility of actually charities providing to the Charity Commission a bulk reporting mechanism, because charities have become acutely aware they have to report these issues in, and they're sending a letter for every single incident, whereas the Charity Commission are trying now to, or asking the charities to actually provide a bulk report, and they're going to be providing, I think, during the latter part of the autumn, maybe even towards the beginning part of next year, an online portal to be able to report serious incidents on safeguarding.
But if there's serious incidents on safeguarding, they should raise a safeguarding concern for the local authority.
They should, they just do not have the capacity to do so.
Absolutely, you're right.
I'm going to close.
Hello. Well, hello, my name is Kenny. I'm a nurse, I'm a midwife, I'm a mental health nurse, and for many of you, I'm a colleague past, I'm also a colleague present, and hopefully a colleague future as well. What I'm about to do is talk to you as not people perhaps that you came into the room on their attendance list. I want to talk to your citizens. Because having been the head of safeguarding for the NHS for 120 days, I think I've done better than Trump. As a head of safeguarding for 120 days, the one thing that I have felt the value of is at any moment in time, on the flip of a coin, you, me, or anyone in this room could be safeguarded or safeguarding, because life is that complex. So what I'm going to talk to you is about how we as people, as citizens, rather than practitioners and employees and chief executives and esteemed judges, wasn't that fabulous? I think we wanted that legal context so concisely and compassionately for a long time. Is to talk to you about journeys that I've had, and I'm continuing to hear as I go out and listen. So as a head of safeguarding in England, I'm chief listener. My job is to come to forums like this and listen to what you need in order to make the NHS and the health sector safer, not only for citizens, but for families and communities. We've gone beyond protecting citizens. We need to have a public health approach, population approach, in order to empower families and empower communities to safeguard better. So part of our conversation will be about protection, part of it will be about safeguarding, but in the end it's all about prevention. We need to stop horrible moments, horrible situations happening together. Okay? So, what does the NHS have in terms of products? I'm going to run through this because I want to have an adaptive conversation with you as well. So at the moment, the NHS has a national safeguarding team. There are about 15 of us in the national team. There's myself and a deputy and a layer of clinical leads who are experienced clinicians and practitioners from all branches of health. And we've got a very small administration team. And what we're now beginning to see is that we have to listen to you as experts. No one in Quarry House, no one at Skipton House, no one in the national team can actually tell you how to manage safeguarding or protection, particularly protection of adults, as we understand is getting more complicated. So what we're going to do is we're going to work with the sort of Safeguarding Adults National Network, and we're going to begin to establish clinical reference groups. We're going to pool your expertise together over a period of meetings for you to tell us best practice grab guides, best practice resources, so that we can empower clinicians and carers, we can empower practitioners and people in the population to safeguard. We're going to create a social movement. No one in this room should leave thinking that you're alone, but no one in this room should carry the burden that you're the only person who can solve safeguarding matters. We've got to begin changing societal values, and you can only do that by social movement. So part of these working groups, part of these networks, and part of these task and finish groups are going to be coming out with suggested materials. Let me give you an example of some of those materials. So, in order to fit the strategic role, these are our strategic roles here. One of the important ones is that we've got to create culture, we've got to do effective assurance, and that we've got to make sure you're engaged. So, QR codes. We are not going to give you massive tomes of information, but let me jump forward to a screenshot. Everything that we're doing now will be digital. Hands up those in this room that has a smartphone. Excellent. Did you know it took us 600 years to go from plough to tractor? It took us a decade to go from analog phone to this. And I watched you this morning, every one of you in this room has been active on this. What I want you to be is active on this for safeguarding. So if nothing else today, get this QR code off the screen, onto your application, and it will open up a whole new array of safeguarding information. It's a new NHS safeguarding app. There's one for adults, there's one for children, there's one for staff, and all your local contacts will be laid on it. So it's been refreshed. Bex, can you stand up? Bex is in charge of that refresh. So if it doesn't work, it's Bex's blame. You know where I am. So at the moment, we down, before 2 Thursdays ago, we had 61,000 downloads. Yeah? About 200 people a day were looking at it. We don't know where you are, but we can monitor. It's called footfall. It's a bit like Marks and Spencer's measures you how much loaves you do by cards. We can monitor this. Last Thursday on Twitter, because I'm a big twit, massive twit, and on LinkedIn, very interesting platform for colleagues, business, LinkedIn, very powerful. We issued the QR code. We have had, at the moment, the reach is 818,000 people have gone to it in 2 weeks. 818,000 people. Hands up those that have gone to it because of Twitter and LinkedIn. Yes. Now that's indicative because as system leaders, every one of you in this room is a system leader, and you will not raise your roar in the complexity of what's happening if you don't use social movement. Because in your office, in your place of work, in your family, you have no reach. And so far this morning, about 7 people are using Twitter about this event. What I would want is double that before the end of my session. Let's go viral. Let's go social movement. Hashtag NHS safeguarding. Hashtag your topic. And we found this out from population health because a nasty moment. 3 years ago, an international student died in London of meningitis. And the bureaucracy I work in, the NHS, said, oh, we've got to write out to pharmacists, we've got to write out to GPs and tell them to take the vaccine and promote it with young people. And I said, you know something, before I write a letter, can I just try something? We sent a tweet with a selected photograph, and we sent it into Twitter. 27 minutes later, we'd 500,000 reach. The power of social media to support you and restore confidence that safeguarding is not to be scared of, safeguarding is not intimidating, safeguarding can bring benefits to people and families and populations, the sooner we use it. So this is one of the things that we need to do to improve our role, is remember that all bar one person, I won't name you, all bar one person in this room has a smartphone, and that's usual. The technology, we need to embrace that digital technology to support people. Okay? But let's go back to, it's stuck. That's technology. Here we go. Every one of us in this room, me as a mental health nurse, as a midwife, as a manager, will come across situations, this is why we're here, whether we're here to be compassionate or whether we're here to be therapeutic, we come across these situations when you think, how do I deal with this? I'm dealing with a team of call handlers at the moment, call handlers, band 3, NHS band 3, and they're expected to handle suicidal thoughts on a call because the SOP says they must close the call with a positive decision. Honestly, I'm going to bring you into them and say, we cannot be held responsible as therapists or administrators or anything in the care sector if capacity says that someone makes a poor decision. It is not for a band 3 on the end of a phone to turn it round. But it does tell me that many people in this room have been put in that invidious positions. Not only as clinicians and staff and people that work in organisations that are caring organisations, but just part of our lives. We are citizens, we can be safeguarded and safeguarding on the turn of a coin. And part of what I've come to critique in my 38 years as a nurse and 120 days as the head of safeguarding is I have to empower people, practitioners and population to have resilience when it comes to safeguarding. And for me, the important section here is adaptive conversations. We need you to go back into your organisations because the person next to you is just as likely to be going through a mental health crisis or a family perfect storm or something in their life course as the person that you're caring for. So I don't wish to disagree with my colleagues from the charity, but I think people in here do have a role and a function to be a critical friend and a listening ear for their colleagues. Some of us have a leadership and management role, but everyone in this room is passionate about safeguarding. But you can only do it if you bring resilience to the conversation. And the adaptive conversation takes someone out of the perfect storm into that recovery zone. What do I mean by adaptive conversation? Where are you, in all the horrible things you hear about safeguarding, where are you having your adaptive conversations? Give me an example of an adaptive conversation that you have as a system leader, as a safeguarder. Any adaptive conversations going on? No? Supervision. Absolutely right. Supervision, whether it's one-on-one, whether it's reflective practice, or whether it's just a huddle. And it doesn't matter what you call it, but please, the one thing that you should not be doing as a safeguarder, if you're going to protect the zone, is wear it and wear it and wear it and wear it. Everything tells us that is a recipe for a perfect storm in you. So one of the things that we're trying to get, as well as products that tell you how to do it, and contacts, these are just a collection of trusted websites and peer-review voluntary sector organisations that support various parts of our system. They're all QR coded. Is to have somewhere that you can be a role model and go and divest yourself of that worry before you go home. So hands up those that have supervision, peer review, have a community of practice. Yeah. About 2/3 of you. Well done. Now this is particularly important for those of you in a leadership position, because some of the things I hear, if I didn't divest myself, I could not be going home to be a dementia carer, which I am. I'm a dementia carer. So when I leave work at 4 or 5 in the afternoon, I need to focus on my neighbour. I cannot be thinking of my job all the time, because otherwise Bob doesn't get fed. Bob's a dog, by the way. Nice little Labrador English Bull cross. 11 years old, neglect dog. We got him a year ago, just in case you wonder. The other thing about resilience is just what I'm doing just now. You see before you the head of safeguarding for the NHS. Really, I'm Kenny. I have a personality. I have a balanced life. You know, I've got me, myself, and I. And I think part of what the adaptive conversation says between us is you've got to let people know that in safeguarding there are various facets that you might need to discuss. So as a tactic, Kenny has always learned, I'm not the head of safeguarding, I'm the chief listener. I'm not the head of safeguarding, I'm Bob's feeder. I'm not the head of safeguarding, I'm actually my neighbour's dementia carer. Because there are people in this room who are carers. And if you cannot decompartmentalise, one of the stresses of being a lead safeguarder in the system is if you wear it all the time, it will have an impact on the other parts of your life. And that's what we call it in adaptation, is rewiring the conversation. You know, if you are a safeguarder, do the people that you live with, love with, socialise, do they really understand the pressure that you're under? Do they really understand the cases that you hear? No, neither should they. So where do you divest yourself out of that? So you need that access of adaptive conversations. Any other route of adaptive conversations? Any life-work balance tips?
Down the pub?
Down the pub, yes. Eat healthy salads down the gastropubs. You've got to have a balance. It's just as adaptive as anything else. What we do in this role, whilst we're august organisation, people are on call, but it is a job. We are paid to deliver on a professional standard. So part of the adaptive conversations is to be honest about what your boundaries are. You know, what are our boundaries as safeguarders, professional safeguarders? What I would like you to do for adaptive conversations is also appreciate that there are now built into the system roles and responsibilities that are there to listen to you. Critical friend, listening ear. And if you don't know who they are or what they are, so hands up those in their system that knows there's a named nurse for looked after children portfolios. Yeah. So if you've got concerns about looked after children portfolio, they're the person to go to. Hands up the designate professionals in this room. Adults, excellent. Designate professionals for children and families, difficult role. These people are set up as chief listeners in their area. They hold the intelligence that certainly I don't. So you have to be applauded. So one of the things that we're doing for designated professionals is we're going to create a development fund of £1 million to inspire more people to be designated professionals in order to support more people like you. So we're listening all the time as to how to make it adaptive. What are our priorities moving forward for our year ahead? Well, obviously, there's reforms to reality. This is our reforms to reality side. So over the next few months, there will be the Domestic Abuse Bill. Yes, there will be the Mental Capacity Act. There will be the Child and Social Worker Act. And it is important in this space to recognise my comment earlier on, whilst protection is about the individual, Safeguarding is about families and communities. So people who specialise in safeguarding the adult do need to understand what's happening in the safeguarding of children and young people. Because invariably, the two blend in families. They certainly blend, if not jar, in communities. So these reforms are important. We've also got the Child Protection Information System. So that's where every child in a protection register are looked after. There's an alert sent to the social worker every time they attend urgent and unscheduled care. This has been so successful that carers of people with learning disability are asking for an equivalent version, so that for community safety reasons, if someone disappears or goes missing, they can check and chase when the last time was that they went to a pharmacist or they went to urgent and unscheduled care. So the Child Protection Information System, very important, the alert system. Prevent. Who would have thought that radicalisation was going to be part of our portfolios? And the legislation around that is going to change. Contest 3 will change. And this is where safeguarding has to come in and give reasoned, legitimate evidence. Did you know that when, before 120 days ago, about 2 years ago, it was thought that Prevent was an anti-Muslim programme? That's what it was. It was rooting out fundamentalist Muslims and reporting them to the police. Thankfully, with social movement, we've changed. It's now about radicalisation. But the evidence hasn't changed. Did you know that people refer to Prevent, the first place they went to was a mental health assessment hub? I mean, as a mental health nurse, I find that abhorrent. That if you're radicalised, you're assessed for your mental health. And what they've discovered in the last 15 months of evidence, and we'll come on to the data, what they've discovered is by looking at the referrals, only 23% of adults referred to Prevent have a mental health condition. 61% have autism. How dare the system badge autism with mental health? So we're challenging, we're safeguarding, we're profiling the fact that let's talk health language, that if someone with autism that is vulnerable to radicalisation on the web, let's call it autism, let's not badge that person with a mental health condition. That does not bode well for mental health, and it does not bode well for citizens who are referred. So the whole system has changed around Prevent, and now citizens on the Prevent referral, because of the work you've done, are now referred to the Vulnerability Assessment Hub, because many of them have the wider determinants of vulnerability, such as lack of job, such as autism, such as lack of empowerment. And so we're working with these hubs to change the culture to be more evidence-based around why people, 61% of them have autism, 23% have a mental health condition. What can we do to stop them engaging in being radicalised and being detrimental to their health? And these are just some of the things that we're going to bring you under the hashtag NHS Safeguarding. We're going to bring you a new safeguarding module. It's not as perfect as we would wish, but it's up to date. So when your organisation needs you to complete a module at level 1, you don't need to go to a classroom. What I've heard today is level 3, let me tell you. If I reflected on what I've heard this morning, I'd be counting myself as level 3 trained. So the MAST module is for anyone working in the health service, but you know something? If we can loan it and gift it and re-gift it to other organisations, ask. Contact me and we will re-gift you the module. We've already gifted it to Public Health England. We're thinking of gifting it to other organisations in the care sector. As someone said, do not reinvent the wheel, just pump up the tyres slightly. Re-gift with pride and use and re-gift with honour as well. Pinch with pride, re-gift with honour. All of these things are bits and pieces that as I've gone round and listened, people said, there's no policy. Well, we'll give you a policy. Not everyone likes policy. Well, we'll give you grab guides. Not everyone likes grab guides. Well, we'll give you 100 separate, quality assured, trusted resources. Do not create it. It's there. Organisations far better than us have created things. Embrace the offer that people make you. Be a bit more resilient. Work in partnership across integrated care systems. But we're going a bit further. Down the middle here is this one. By next year, we will be working with the Safeguarding Adults Network to take recommendations from domestic homicide reviews, safeguarding adult reviews, serious case reviews, mental health death reviews. And we will ask the Safeguarding Adults National Network to work with the National Safeguarding Steering Group that you saw in the first slide to tell us what local themes, regional recommendations can the nation learn from and cascade them. So we'll be doing integrated data projects looking to take all the local fabulous... Did you know that families give their hearts and soul 3 times during the death of a loved one? When the person dies in horrible situations, it's traumatising. When they come and sit at a serious case review or a domestic homicide, they give their heart and soul telling you what should not have happened. And the third layer of unacceptable tragedy is when we do nothing with it. We have got to stop this black hole of asking people to come to these horrible situations, giving their heart and souls at independent inquiries, at regional safeguarding reviews, independent safeguarding reviews, and we end up doing nothing with it across England. So we're going to be working on an integrated data project. We're going to be taking every lens. There are 12 safeguarding projects in adults, including county lines, including a new one called counter-terrorism in Contest 4. It's in the wings. We will take all of that data. None of it's confidential. None of it's about me. None of it's about you. We will lay it onto Public Health England's fingertip demographic data, and we will allow you to use it to influence. So we're not going to allow protectionist localism of data. We will take it regionally, we'll take it nationally, we'll build it into Public Health England demographic data so that by integrated care footprint, you can have a debate with your safeguarding boards about which communities and which families are the most vulnerable. So we're going to stop 12 streams of data and we're going to start using integrated data. We're also going to expect reflective practice. We're going to encourage every nurse, every carer, every practitioner to begin looking at using reflective practice. What did you learn? What will you change? What do you need to know more about? So on the back of the first draft, there'll be a new page that you can count in your portfolios and you can share across supervision. Obviously, you'll protect confidentiality. So we're trying to raise people's roar. We're trying to shine a light on all the fantastic, fabulous work you do. And we're trying to give you that voice. Okay? Obviously, we started raising the voice by intercollegiate document adult. Really incredible, powerful. For the first time in 40 years, you, adult safeguarders, have a list of competencies that tell you what training, what competencies you would require to provide. That's an incredible bounce board. What we've now got to build is all the resources that equate to the training. So for those of you, I think we should thank presenters here because this is level 3 training, provided you do reflective practice. Attending it doesn't count. It's thinking about the implications of it. So we've got to thank the intercollegiate partnership for this as well. In December, if not November, we're going to get the children's version again. And what we'll do with the Safeguarding Adult National Network and yourself is we'll come back out to you after 6 months and ask you, what do you need in the next version? It has to be revised and refreshed because new people will come on board. So those are the types of things that we intend to do. That's our website, but sadly, until Bex gets, I think, 32 days in post,
Yeah.
it's still 2016 in its version. So I wouldn't bother going to that. I'd probably go search social media, whether it's LinkedIn, for all the new up-to-dates, and get yourself into the zone of, let me go back, technology. Oh well, we'll get you the QR code in order for you to get on with the app first of all. But then Bex is working on new grad guides. We're going to be doing blogs. We're going to do tweets, etc., etc. Okay. So that's how we are supporting iteration. Thank you very much.
Thank you very much, Kenny. Finishing in record time, I think. We do have some time for specific questions for Kenny, and then I'm going to ask our other speakers for the morning to also be prepared, if you don't mind, to answer any further questions from the floor that weren't taken up previously. But some questions first, I think.
Hi, thank you very much for that inspiring talk.
Thank you.
In my reflections, I consistently come up with two queries. There's a huge amount at the moment going on about safeguarding,
Yes.
training people, etc. The two things I consistently come up with is how do we solve this? And one answer is we need a good, well-trained workforce. We need enough people with enough training, with enough education, who are valued by their institutions, paid appropriately and looked after by the system. I can't inflict that and I don't see it happening. The second thing is, I haven't seen anything on any slides about how we identify perpetrators and help retrain perpetrators so they are not just linking in with paedophile rings and looking for vulnerable adults, so they can find a different way to behave. So those are the two
Those are the
things.
two things.
I can't do it without you.
Oh, I think you can. You asked the question.
Tell me.
You asked the curious question, which is always the start of transformation. So thank you. So the first thing is training. None of us in this room will remember everything that happened in this room. Coming to training is only the start. And the intercollegiate document summed it up nicely. Only 50% of your development needs to be face-to-face. I've done my whole CPD portfolio as a nurse on social media platforms by reflective practice. I don't meet that often, but I think we've got to get more creative and curious about learning, not wait till we're trained. You know, what I've learned in this room with the two speakers and listening to some of your questions, that's learning. And we've got to begin taking responsibility for learning safeguarding as well as going to somewhere to be trained by it. You're the experts. So collaborative learning. The second thing is a very real question at the moment, the perpetrators. So there's a real strategic, fabulous way to look at some of the perpetrators are perpetrators because they were victims. Yes. And that's a sound way to think. So the health and the justice health system has actually begun profiling that. So their first lifetime offer is to people who have been sexually abused and assaulted. That will happen. Their next offer coming out very shortly, linked to prison health and linked to custodial health, will be how do we take a perpetrator and make them societal again? So it's reablement. Now, that's a longer journey because most people, unlike us, possibly wouldn't vote for that. You know, there is still a mindset out there, lock him up, throw away the key. And I've learned enough and listened enough in order to know that that doesn't fit every citizen who is a perpetrator. So I think I will go back to Kate Davies, I will go back to Hong Tan and say, okay, we've taken care of the victims, the survivors. Now let's profile with the SANN and this forum, let's profile what we're doing to rehabilitate the perpetrators and get them back to understand what it is to be societal. So we will be communicating with you on that basis. But the moment is about to come, and that's what we're talking about with the Ministry of Justice, and that's what we're talking about the Ministry, the sort of Home Office and the Department of Health. And they're listening, they are listening.
Just to comment, both of those are excellent, but everything needs enough well-trained, well-looked after staff.
Yeah.
And to that happen.
No,
NHS social services.
Yes. I am aware that local authority public health budgets are being cut, and that has had a detrimental effect. 30% of school nurses, 25% of health visitors. We're in the room, we're living that in social services, etc. I will do what I can to influence effective staffing levels. I don't think you need safeguarding in your name to be a safeguarder. I think safeguarding is every one of our jobs. And so where I am at the moment with that is I'm with the Academy of Royal Colleges and the GMC and the NMC and the Allied Health Professional trying to influence that the safeguarding module must be implicit, contained within pre-grad training. So people must qualify as a practitioner with a sound understanding of safeguarding and the various lenses. So I want to embed it into that. So we're having conversations about curriculum development as well. Okay.
So I'm a named doctor for safeguarding adults, and I also still work in primary care.
Yeah.
Something which I think has been brought into my mind this morning is the issue that we're being encouraged to socially prescribe all the time now. And we have a system for social prescribing.
Yeah.
So I now prescribe to people that I don't actually know who are, I don't know how they're regulated. Whereas up until now, my job's been quite safe because I've only referred to people within the NHS where there is a review structure, and whether it works well or not. But how do you feel that we stand with this issue of social prescribing?
I think the rise of social prescribing, as the rise of all hear and treat services, is not going to stop. I think we have a modern population that whether it's social prescribing or I just want to talk to someone on the internet and get sort of feedback, that's becoming more of the norm. And it doesn't fit with how I was trained. I was trained to have a presence. I was trained to build trust in relationship. So it doesn't appeal to me as a clinician. I don't think it's going to go away. Social prescribing is one way to deal with loneliness. It's one way to deal with the other vulnerabilities of adult safeguarding. But for me, personally, there's no substitute for relationship building. Whether that's with a public health practitioner, or a GP practitioner, or a named GP, or a nurse, or an allied health professional, or someone from the third sector. People who are lonely and prone to safeguarding do need a presence at some point in order to be with someone.
But have NHS England safeguarding thought about implications of primary care doing social prescribing? That's what I'm asking.
Yes, there is a social prescribing team. What I will do, if Bex and I take your name, we will go to them and communicate with you outside the room. Does that help?
Yes.
Okay.
Michael, and then a question is about.
Okay, my question sheet. I chair 2 safeguarding adult boards. I write safeguarding adult reviews.
Yeah.
Social worker by background.
Mm-hmm.
I'm feeling a bit frustrated, if I'm honest.
Okay.
And I'll tell you why. In one of your early slides, you talked about priority being to support the raising of concerns.
Yeah.
and you identified another priority about learning lessons.
Yes.
One of the lessons we've learned in the NHS and indeed in local authorities about raising concerns is that if you blow the whistle, that has serious consequences for oneself.
Okay.
So my challenge to NHS England, if it is a priority, is where do you roar? Because the law on the protection of whistleblowers is inadequate. That is a lesson that we have learned from Mid-Staffordshire, from Winterbourne, we have, to my certain knowledge, 180 and counting serious case reviews and safeguarding adult reviews on adults who self-neglect. As you may hear from Jill Manthorpe later, we have umpteen safeguarding adult reviews on other types of abuse and neglect. What emerges from many of those safeguarding adult reviews and their predecessor reviews is that the working context which we are providing for healthcare staff and for local authority staff, the time for reflective practice, the workloads to enable reflective practice, adequate training at pre-qualifying and post-qualifying levels, and so forth, is inadequate. Where is NHS England, and for that matter ADAS, roaring? We need to be roaring in the direction of Westminster, not simply producing, important though it is, more resources, as you had on your slides, to encourage people to do more with less. So my challenge to you and to your colleagues for your 121st day and beyond is where do you roar, and how do you tell us in this room and beyond this room when people who need to listen to take political decisions are listening? Because if they are not listening, East Sussex, Northamptonshire and NHS trusts running out of money will not be single organisations. The whole tower, the whole edifice is in danger of collapse.
So where I take, it's a very, very useful question. Where Kenny takes his roar is what I do as a clinician, it's what I do as a citizen. I go to the heart of the money holder. So yesterday, I was at the Home Office, and the day before at the Department of Health, and we have all but argued and debated, and I am 99.9% certain they have agreed to give us an extra £1.5 million to develop resilience and capacity at the designated practitioner level, or named GP level, that system leadership role. Because I have sufficient listening from forums like you to hear the applause, but without giving me that information, without giving me those lessons, I have nothing to go in and argue. So we've turned an 8 million national budget for regional, local and national safeguarding into a £12 million budget for the next 2 years. We're recommending over £1 million leadership development, focusing on safeguarding. And as I say, as soon as it's guaranteed, we'll be coming to you. The national network is coming to you. And the other thing that is 90% certain is we have got to move boards, chief executives, chief nurses, chief directors, to the point of appreciating the value of safeguarding. It's not 8th on the list, it's second on the list after quality and safety, is safeguarding. And so what we're recommending, the only thing I have as a lever is something called the contract. And from April, there will be on every contract in the NHS a CQUIN, a quality improvement, innovation, merit payment that says if you come with us on this journey and support your staff, get the right staffing in and safeguard the people that come into your contract, we will give you a bit extra money. It's a stretch target. It's the only arena. We're in an efficiency cross-government, and I think, hopefully, having some extra money into a board with very clear indicators about raising their roar and £1 million development over the year for people like you. Hopefully that explains where I'm going, because all I'm doing is repeating their clause in a way I know influences politicians. The gentleman's right, we have to influence politicians, and I take your voice and I'm able to craft it in such a way that influences £1 million yesterday, a 1% CQUIN the week before. So I need to hear this feedback.
Okay, we have one more question, then we'll open it up to all panellists. Maybe continue some of this with them.
Hi, I'm Kath Gormally. I'm the Director of Social Care in South London and more to the NHS Trust, so like yourself, but from a social work background, in mental health. And I thought your presentation was fantastic. It's really good to hear about the networks and national priorities and the resources particularly. But in terms of system leadership, I was wondering, as we go further and further nationally into integrated care organisations and adult social care, transferring social workers and social care staff to work within the NHS and alongside the NHS, how are we joining things up strategically?
Okay, so strategically, from December, I will no longer be employed by, my staff will no longer be employed by NHS England, there'll be NHS England and NHS Improvement. So assurance will come into performance management and they'll be there. They will also be devolved to regions. We don't need people sitting nationally, we need people influencing locally. So all but myself will be sent regionally to support integrated care systems. I've already delegated my deputy on appointment to a fast-track integrated care system. Integrated care, the new ways of shaping services, care and health, need to have the voice of safeguarding, your voice, at it now. It's too late once they're formed. So we're there, we're devolving staff, we're delegating staff, we're seconding staff into those evolving systems. And if you don't have someone who is an expert in safeguarding, remember, every CCG has a designated professional. Hands up the designated professionals. These people are the subject matter experts in your local safeguarding. You know, okay, it's not a mandate, it's not statutory, children's is, but hopefully with the new reforms, there will be a requirement to have a system leader who's a designated professional to hold all the threads of what's happening. Because it is not about protection anymore. It's about modern slavery, it's about all those horrible things that happen and impact on adults.
I just think it as well as a strong social work program.
Yes, absolutely. So the chief social worker is, I have conversations with their department as well. Absolutely. Thank you for that.
Thank you, and thank you for all those questions. And we've had three very inspiring talks, I think, this morning about balancing the power and responsibility, about gathering evidence to change services, and also about the transformatory or adaptive conversations that we need to have in order to continually improve our safeguarding work. There's been a lot of questions. It's now, we've got 10 minutes or so before lunch. I can see it being set up, so I can feel my stomach rumbling. But we've 10 more minutes to ask questions of any of the panel members from this morning. So over to you. And please say who you are and who you want the question directed to. Mike.
It's not a question, it's an observation which I've actually already shared with Paul. Sorry, I've forgotten your first name. Luke. I chair two safeguarding adult boards. I also chair the London region group of independent chairs. And it strikes me that for those safeguarding adult boards like the two I chair that have services run by charities that are located in their areas, those services should be brought into the ambit of that safeguarding adult board. And one possibility to tie small and larger national and local charities into the adult safeguarding architecture might be for the Safeguarding Adult Board in whose area a national registered office is for a national or a local charity takes on the responsibility for linking with that charitable organisation. And in those regions, like the London region, where there is a well-developed architecture, there is a London Safeguarding Adult Board, for example, into which all of the London Safeguarding Adult Boards contribute, that too might provide a mechanism for tying charities of different sizes into the adult safeguarding architecture and the reassurance that hopefully comes out of that. So that might be something that the national charities and the Charity Commission might want to take forward with the Safeguarding Adult Board architecture.
Thank you. Any response to that, Luke?
Yes, please.
Yes, please. Right, yeah. Okay. Any further questions for any of the panels? Yes, Steve.
This was a question, more an observation. A lot of people said today was specifically about structures and systems. The big thing which has to change is culture, which we mentioned briefly. It frightens me, because I also author SARS, actually being said, could you use that word? It's emotive. The word was failure, because somebody had failed to follow a procedure. Actually, some commissioners saying, it's not our fault, the service providers can do their job. But where the hell were your quality assurance process? Because it is very, very defensive still. And despite the fact that SARS are actually set up to be learning experiences, to actually shine a light for people to learn and be honest, systems aren't actually allowing people to do that as far as I can see the SARS which I'm actually involved with. A lot of the time it's actually about cut down the number of recommendations, you want 3 or 4. The fact there's 15 or more because there's bad practice out there or bad systems they've got actually gets ignored. Until we actually do something to change that culture about organisations, particularly monolithic organisations like the NHS and some other actually saying we got it wrong and saying to elected members we are running a risk because you're not giving us the resources or you can't give us the resources we need to make things safe. Things aren't going to change.
I think things will change. We have a seminal moment, you see, because working together guidance categorically, explicitly, emphatically lays it to the accountability of the Chief Executive of the CCG, the police, Chief Constable and Director of Children's Services. There's a triumphant responsibility now. Now, if we can do it for children under working together, I think it will be a seismic shift for health actually accepting. They have to assure themselves, clinical commissioning groups have to assure themselves that every provider is cognizant in delivering effective safeguarding. Now, at the moment, it is around children, but very quickly with the reform, we should be seeing some shift to maybe include SARS as well. That's what my hope and aspiration would be. That it's given the same parity, the same equity as a serious case review on a child. Because
I thought the Care Act actually put responsibility on all partners to work together.
Yes.
And there's a duty to do that.
Yeah,
and
a duty.
That's right. I think it's not being honoured effectively.
Yes.
And the fact that people are starting to do something, that's about system again. It's actually about changing that culture.
It is.
People operate.
Yeah.
This is supposed to be a discussion as well. Can we build on that? You know?
I've got a question that I'd like to ask Mark Hedley, if that's all right. I'm a known GP and I've got an interest in the Capacity Act and I give help and support to GPs in our area. We've done a lot to try and raise awareness. And the thing, as you said, that frequently holds people is this unwise decision. And clinicians feel very nervous when a patient is making a wise decision. And we talked through about capacity assessment, what the decision is, what they need to do. But I always give advice about if they make the wise decision, don't walk away from it. But what does the court of protection ever do that? If you make a decision that somebody has capacity and it's an unwise decision, Do you just leave it at that, or do you provide guidance about what you feel may help?
As far as the Court of Protection is concerned, the only gateway to its welfare jurisdiction is capacity. So if there is no capacity, the Court of Protection has no jurisdiction. Sorry, if there is capacity, the Court of Protection has no jurisdiction. That's not to say that in the course of an individual case being worked out, there won't be quite a lot of input. But at the end of the day, the Court of Protection is effectively exercising a guardianship over the state's, the limitation of the state's right to intervene in private life. And if the person has capacity, then the state has no right to intervene. It may retain the right or the duty or the power to still to guide. I mean, I think, you know, social services is not entitled to walk away necessarily. But as far as the Court of Protection is concerned, it simply is without jurisdiction if the person has capacity.
Providing they're eligible social care needs.
Sorry?
Providing they're eligible social care needs. Where I struggle is we have a very honourable from Staffordshire and principal social worker for Staffordshire and on the statutory services lead.
Yeah.
And we're doing some work with our local councils at the moment because we had a young woman very recently who was homeless. She made herself, she was kicked out by her parents. There was no eligible social care needs. She took herself to Birmingham, which is where she decided that she wanted to be living. A counsellor from the local area heard about this, thought it was really not really good because she was really quite vulnerable. So dispatched Westminster Police to bring her back to Staffordshire. Under what jurisdiction, I have no idea.
No.
She didn't feel that she was allowed to leave. The council was putting a lot of pressure on the council to say she's really vulnerable and she needs help. She didn't want help. She had capacity to make the decisions that she'd made. She wanted to stay in Birmingham. She was building a life for her there. But trying to have that conversation on eligible social care needs is very, very difficult for people who don't always get it.
Yeah. I mean, that is the absolute classic, isn't it? Where your instincts to protect and do good result in you assuming powers you haven't got. And I think we do see that happen from time to time. I mean, well, you only have to go back to all the Bournemouth stuff, don't you? I mean, what did local authorities do before we had the Mental Capacity Act? It's a very interesting question, to which there was never a satisfactory answer. And I still think we're in that. I'm sympathetic to people who find it extraordinarily difficult to watch someone make a decision they're entitled to make, which is not thought to be in their interest. And I say, those cases I've had like that, I see it on my memory, not because I feel guilty about them, but because they're just a very stark reminder that human rights come at a price.
But isn't the paramount principle of the Care Act about well-being? And the Care Act is not designed to sort and sift eligible care needs. So I think if you frame it in well-being, then you end up in a better place, really, about what promotes the person's well-being, what promotes people who might have been classed as her carers' well-being, and take it in that way. So I think the bit about social services is going beyond that and thinking about well-being and using that theory.
You've got lots of cash.
No, it's not. No, it's not.
But
You can't aggregate responsibility.
No, but it's about cash. If you don't have services that are designed to pick up a vulnerable adults need, for example,
yeah.
What is it that you are offering? What we get in-house is consistent.
But again, that goes back to Pete's question about systems and whatever.
We get
and framing it on well-being is the
learning disability service who don't have a learning disability because nobody knows what else to do with them.
Yeah.
I mean, actually, most of us have got lots of personal experience in this. I always thought parenting was relatively straightforward after 18. I've since discovered it's relatively straightforward before 18 and it gets difficult after that, because you are watching people make decisions which you may or may not agree with, but which you simply have to let them work out. So I kind of think we all experience, or not all, but most of us experience that these kind of tensions and translated into work, they're extremely difficult. And I'm deeply conscious that the police who fixed her back from Birmingham will have in mind what would have happened if she'd come to grief in Birmingham. All hell would have been poured on us, as it would have been. And you know, the excuse was she had the right to make that decision. All you're met with is, well, that's what they said at Rotherham. So, you know, there are real tensions bubbling around that we do need to be aware of. And I think, I was saying to someone before that sometimes we are inexact in our thinking about capacity, because we assume a person has capacity, whereas they might not at that moment have capacity to make that particular decision. And we just need to be alert to those possibilities, just as we need to be alert to the possibility that a person who appears to have all sorts of vulnerabilities may actually have capacity in relation to that decision at that time. And it's difficult. I mean, far be it for me to pretend it isn't. But that's the world in which we live.
We're just about reaching the end. We'll have two further questions, if they're very quick. Please, one from Paul or a comment from Paul, and then we'll break for lunch. Okay.
It's a question to someone. I've already asked someone this question, but I wanted to share with the wider audience. Someone makes an unwise decision, and they have capacity, but they're at risk, and the wider community's at risk. Where do we stand?
Yeah. I hope I can remember the answer I gave you. I think it was definitely along the lines that, again, we need to be quite precise about capacity. We were talking, weren't we, about a person who has oxygen in the house and insists on smoking and rather casually around the place and lives in an area where, you know, everybody else around might get blown up. And I think that those are issues about asking questions about capacity, saying to people, do you realise what the consequences of smoking are in these circumstances? Are you content to run the risk that people should be blown up? The chances are you're going to get a no to one of those two questions, and you're then going to have grounds for saying the person doesn't have capacity to make that particular decision, because they are desiring the opposite of what actually their behaviour may achieve. So I think it just brings us back to the fact that we need to be willing to investigate capacity on a decision and time basis without any preconceptions. Or no, you can't do that, without too many preconceptions about what the outcome might be. The reality is that, though I state that the thing in very broad terms, the reality is that in the vast majority of cases, we actually find a way to address it. You know, the occasion when you walk away and say goodbye to somebody who's going to finish themselves off are exceptional. Normally there's a way through. But I think that is the answer. You do have to press the issue of capacity as to whether they actually understand the implications. And I think I learned this in the person refusing all treatment in the midst of giving birth. That so long as you ask the right question, you can find very often the right answer.
Thank you. Final question, then we'll break for lunch.
Sorry, it's a question for Mark again, sorry. And I think you just answered it actually, but it was just interested in decision making as a judge and as a human being, I suppose. And whether you feel that there's enough in your toolkit, or whether the Constitution or the law offers you enough, or whether there's more that could be available to the High Court, and if so, what? And what would you campaign for?
It's only 20 years ago that we sold the concept to judges that they needed training. There's a very strange culture that is around. There is actually, we have nothing of the equivalent of supervision or anything like that, or any of those kind of backups. The only thing we share in common with you is the system gives us no time to think. If you want to think, then you must do it in your own time. There certainly isn't any work time available for it. So everybody has to devise their own. One of my reasons for defending High Court judges out on circuit living in lodgings is that is actually an extremely good place over dinner and afterwards to unload. And people do take that opportunity if they know each other and are reasonably trusting to each other. That's very important. My poor partner, you know, has spent 45 years carrying these kind of burdens on my behalf. And without her, the system would have blown up. So there's that. And you have other sort of mechanisms. So I operate within a church structure. I have a spiritual director, and, you know, all that kind of stuff. So those are all parts of inbuilt support systems that I depend on. But each person does have to find their own. And I know some of my colleagues really struggle with that. The system is not ideal, and part of the trouble is that the range of work has shifted so far and so much in recent times. I occasionally think, what would it be like if the family judge from 1950s, when I grew up, came back and sat in court today? He, for undoubtedly that's what he would have been, would be completely astonished at what it is we're confronted with. And I was saying at a conference at Great Ormond Street recently, I wasn't saying, somebody else was saying, but, you know, when you trained as a midwife, when my wife trained as a midwife, children either lived or died, you know, that was the way the world was. Now the skill of intensivists is such that in a highly specialised hospital like that, or All the Hair or whatever, children only die when a human being decides to allow them to do so. For the most part, we can keep them alive. So we have brought upon ourselves all manner of decision making we have never had to confront before, at a time when we have actually less ethical tools to do it, because we don't have a common ethical basis anymore, as perhaps 50 years ago we might have done. And those are colossal issues which I think we're all wrestling with still.
It wasn't 50 years ago I trained. They didn't do 5-year-old training.
You've just given your age away, Kenny. Thank you very much. And if we could put our hands together again for our speakers.
I'm Mike Preston-Shute, just in case you didn't know. And I'm chairing this afternoon, and I'm delighted to say that we have all our speakers here, which is great. A few introductory comments from me. This afternoon's session feels a bit like coming full circle. And as somebody whose first degree was in history, I went back to my written record of a seminar that we held, the first seminar that we held on the 22nd of January 2016. The focus of which in the morning was, how did we end up with the adult safeguarding provisions in the Care Act that we ended up with? And in fact the morning was kicked off by Alex Ruck Keene, at the back there, one of our co-conspirators in this seminar series, and indeed Alex is bringing the keynote speeches to a close this afternoon. So in one real sense, this is coming full circle. So I went back to my notes, and obviously my written record is somewhat partial, as all historical records are, but I made the following notations of what two of the speakers in the morning on that day actually said. One of the speakers talked about fervently wanting a power of access in England to enable confidential interviews to take place when there was reasonable cause to suspect that access to that person was not available. As you will know, in England we did not get a power of access, although colleagues in Wales did, and indeed such a power has existed in Scotland since the Adult Support and Protection Act 2007. And Jill will present in a little while on further research on the case for, and quite possibly the case against, a power of access for England. The same speaker said something along the lines of, why did the Department of Health, ministers, the Association of Chief Police Officers get the new laws so wrong? You can see that he was obviously coming from a particular viewpoint. Norman, when he speaks in a moment, may wish to talk about reflections over the last 4 years about the degree to which ministers and civil servants got it right or got it wrong. Another speaker talked about the coalition government and the challenges of negotiating the legislative process through something which England and indeed the UK had not experienced in living memory. And she talked about the madness of doing legislation of such a scope, at such a pace. And she talked, for example, about the Care Act receiving royal assent, if I'm not mistaken, in June 2014, and a requirement that the Department of Health, as it then was, produced the first iteration of statutory guidance in October of that year. And as we know, those of us who are involved in adult safeguarding, there have been several iterations of the statutory guidance subsequently. And she was also asked, in fact by somebody I know well, what might make the difference in terms of us presenting evidence to those who have the power to act on that evidence. And I wrote down her response, and I've never forgotten it. And it was that we should humanise our evidence. In other words, that we should present case studies that are meaningful in terms of the changes that we wish to see. Of course, safeguarding adult reviews are part and parcel of that evidence, and indeed there have been some safeguarding adult reviews, as Jill may well say, which have highlighted the challenges of negotiating access to individuals when there are family members who would seek to prevent such access. Beryl Simpson, SAR in Kenton Medway, Adult D in Newcastle are just two such examples. So, I love history because it reminds us of things that have gone and the relevance of things that have gone for things of the present and indeed the future. So I'm delighted to kick off this afternoon with the Right Honourable Norman Lamb MP, who was, at the time, Minister of State, is that the correct title? Yes, Minister of State, responsible with colleagues in government for piloting through what was the Care Bill to become the Care Act. And he's going to reflect on policy development and learning in adult safeguarding. And I'm, for one, going to find it fascinating, as I'm sure you all will. Norman, a very warm welcome, and thank you very much for coming.
Thank you very much indeed. Good to see you all. I always believe in getting my excuses in first, so I will tell you all that a week ago today, I had a hernia operation at the James Paget Hospital in Great Yarmouth in Norfolk. I was doing the mystery shopping for the NHS, and I've spent the last week in rather a pathetic state at home, trying to do emails and paperwork, but also feeling rather miserable and anxious as a patient, and I'm not a very good patient, I've discovered. So if I keel over, you'll sort of understand why.
We have nurses in the room.
It's a good place to keel over. So first of all, just by way of clarification, the discussion I had prior to this was that I should focus particularly on the aftermath of Winterbourne View, the Transforming Care programme, what's happened with it, the successes and failures, and where we are now, rather than specifically other issues related to the Care Act. I'm of course happy to discuss other issues as well. So I would just, I suppose, begin with a very brief reflection on the Care Act. I think it's actually quite a good piece of legislation. Now, of course, it's self-serving for me to say that. I took it through Parliament, I accept that. But I don't think it's right to say that this is legislation taken through in a great rush, actually. There was a draft Care Bill that was produced, in fact, by my predecessor,
which went through a whole deliberative process in Parliament before the final care bill was tabled in Parliament. And actually, during the course of its passage through Parliament, we made loads of amendments in response to lobbying representations from a variety of people. And I do remember at the time that it was passed into legislation that there was I would say, a broad welcome for the legislation. Absolutely, I'm quite clear and sure that we got some things wrong and that there are some things that can be improved. And on the right of access point, I will absolutely sort of plead guilty to finding it an extraordinarily difficult issue to reach a view on. Because I was subject to really strong conflicting views on that. It tended to be local authorities who were most strongly advocating a legal right. But there were also organisations representing individuals who were arguing very strongly against that. And it was quite striking that it seemed to be institutions in favour, individuals broadly but not exclusively against. And I suppose all I would say to you, those of you who have a passion in one way or another, as a minister you have to make a judgment. And when you're confronted by strongly conflicting evidence and advice, you have to make your best judgment. And we reached the conclusion not to grant a legal right. Taking the view that a social worker's skill is in a sense the negotiation of access and communication with those people involved in care. But I also absolutely recognise that a conclusion might be reached that that needs to change and that we need to reduce it. I'd be fascinated to look at the experience in Scotland where there is a legal right, and I'm totally open-minded to reaching a different view to the one we reached at that stage based on evidence. I fundamentally believe in policy making based on evidence as far as you're able to. It's not always easy, given conflicting pressures on you, sometimes given the paucity of evidence. But I think that that's a fundamental principle that we should stick to, even at a time when I think rational politics and evidence-based policy making is more difficult than it's ever been because of the rise of populism in our politics. But we need to try to stick with that principle. So I wanted to reflect particularly on Winterbourne View and then what's happened as a response to that. I became Minister of State for Care and Support in September 2012. So we were already into consideration of how the department should respond to the horror of Winterbourne View. And one of the things that occurred to me pretty early on was at no stage had anyone actually invited families of people who had been patients or residents in Winterbourne View to talk themselves about their reflections of what had happened. So I invited families to come into the department to give their reflections to me directly. And I can remember one dad, a guy called Steve Sollers, who came in and he talked, I think very movingly, about how he watched his adult son deteriorate as a patient in Winterbourne View. He told me how initially he'd been openly invited into the building, he could visit his son in his bedroom and so forth. And then progressively he was only allowed into the reception area, and there was a barrier beyond that. He said, I watched as my son became increasingly zombie-like. They were obviously using antipsychotic drugs on him consistently. He put on a lot of weight. And here was the thing that really disturbed me, because he said then that I tried to raise my concerns with, at the time, the Primary Care Trust and the local authority. And he said no one listened to me. No one took my concerns seriously. And he said I ended up feeling guilty as a parent that there was nothing I could do for my son. Now, I just think we have to reflect on that for a moment. What sort of system is it where we leave a parent feeling that no one is listening to them and that there was nothing he could do for his son as he watched him deteriorate? But that was one family's experience of the system in this country, and I was horrified by what he described to me. So we then moved to the completion of the Transforming Care document. It was published in December 2012. It was a concordat. So that meant that really all of the key national organisations came together to sign up to it. And this is important, to commit to implementing the concordat to deliver a transformation of care for people with learning disability, people with autism, people with behaviour challenges. It was difficult at that time because the department and the NHS kept no data of what was happening to people with learning disability, people with autism. There was no data on the numbers who were in inpatient care, no data on the flows in and out. I always used to describe that I was operating in a fog. We had to rely on periodic audits of the system to find out what was happening. So in December 12, as a minister, we entered this concordat. And I believed, and I think looking back, probably naively, that an organisation like NHS England, which was obviously one of the key signatories, meant what it said when it signed up to Transforming Care. When we did an audit then, I think about a year to 18 months later, I was horrified because nothing had changed. It was absolutely business as usual. And what became very clear was that private providers were making investment decisions to invest in new facilities, obviously on the assumption that nothing really was going to change, that they felt confident enough to invest sometimes substantial sums of money in new inpatient provision at a time when the national policy was clearly to move away from the degree of reliance on that that we had. St Andrews in Northampton is a case in point, a very substantial investment. This is a so-called third sector organisation, but where the leaders of the organisation earn a fortune, and the organisation receives very substantial sums of money from the taxpayer to provide, in my view, the wrong model of care to many individuals. And I'll give you an example of that now by way of a case study. Sometime after we had published Transforming Care, I was approached by a family of a girl called Fawzia. Fawzia had been admitted to St Andrews at the age of 15. She was there for about 2 years. The family said to me, would you visit her at St Andrews? Now, interestingly, I'd already agreed to visit St Andrews at the invitation of the organisation, and that visit was due 2 or 3 months hence. But I said, yes, I would. And this, you have to understand, this is highly unusual for a minister to just turn up at an institution on the invitation of a family. And I arrived there, and the organisation was clearly discomforted by my arrival. I was taken down into the ward where Fawzia was an inpatient, and I was horrified and disgusted by what I found. She was living in a room which was in effect a prison cell. It had a padded bed fixed into the wall. Next door to it was a seclusion room which was even more bare. Nothing on the walls, just a plain square small room. She was repeatedly put into seclusion. Remember, this is a girl aged 15/16. She was repeatedly subject to physical force. The use of restraint was a regular feature of her care. in that organisation. The family who I met with, so happened she was lucky enough to have a clinical psychologist as an aunt. And it was that aunt that had spoken to me to start with. They were quite clear that there were clear breaches of the Mental Health Act code of guidance going on there. I was so horrified by what I saw. I mean, she was in effect being treated like an animal, in my view. Because of the constraints that she was subject to, because of the trauma, I think, that she went through, and because of her acute autism, she ended up experiencing seriously deteriorating behaviour. She would spend most of her time taking all her clothes off, racing around with no clothes on, and the organisation's response was to put her into seclusion. Now, I went back and said, we've got to get her out of there. I wanted an immediate review of her care. And that started a process which some months later led to her being discharged from that hospital to a place called Alderwood, also internally in Northamptonshire. Fascinatingly, I visited her 2 years later. From the day she was discharged, she was never restrained again. Now, just think about that for a moment, because if that is the case, and if that was possible because Alderwood had trained their staff, not only in autism generally, but also in how autism affected that individual. And it was an organisation, private sector, but an organisation that clearly cared about the people that they were responsible for. She was living a wonderful life. She was outside, she was horse riding, she taught 10 to the dozen when I got there. This girl who'd been just cowered on the bed in a really bad state. When I got there 2 years later, she almost immediately said, "When's your birthday?" And my birthday was about 3 months hence, and I said 16th of September. And you could see the brain whirring around. She, about 5 seconds later, she said, "That's a Saturday." And I was just gobsmacked. And you saw this extraordinary brain operating in a girl that was now enjoying life. Still very complex, but being treated in the right way, not having her human rights abused, as I believe that they fundamentally were in St Andrew's Hospital. Now, let's go forward to now, because Farnham 4 did a report on the Transforming Care programme last week. And depressingly, there are still case studies of the same abuses of human rights going on now. There has been progress. There are fewer people now in inpatient beds, but it's way, way short of what it should be, and of what in 2015 the government committed to get it down to by a third to a half by next March. They also, through Freedom of Information, revealed that the use of restraint, including face-down restraint, has increased. Now, I issued guidance as a separate issue, looking at mental health care and also learning disability care. I became acutely interested in the use of force in institutions, and I initiated a review of the guidance, and it resulted in clear guidance that the use of face-down restraint is inappropriate and should not be used, and that any use of restraint needed to be radically reduced. And when you visit progressive practitioners, progressive organisations, you can see how they have managed to almost eradicate the use of force, but it remains endemic in the system. And there are very many places where, under often intense strain, lack of resources, use of agency staff, and so forth, and a lack of will and a lack of leadership, the use of restraint is as great as ever, if not worse. Going to Mersey Care in Liverpool, Joe Rafferty, a very inspiring chief executive there, has led the way on reducing restraint. They have a policy called No Force First. I visited there. on the day I visited, there was a cellist from the Liverpool Philharmonic Orchestra playing cello to a group of blokes on the ward. The culture was completely different to what you would normally expect. And they had managed to significantly reduce the use of force on that ward. They've now spread it across the whole organisation. And what they see is staff absences go down because fewer staff are getting injured at work. So there is a way. And yet the failure of leadership to drive through a change of culture, I think, is really shocking. Why do I think the programme, the Transforming Care programme, has ultimately failed to transform care for very many people? I think there are a number of factors. I will just run through some of them very quickly. First of all, I think there has been a complete failure to do what the Transforming Care Concordat said in December 2012, and that is to pool resources between NHS England and local authorities. So there is a clear perverse incentive on local authorities to take responsibility for people. Local authorities under intense stress financially, overspending on their adult social care programmes, they are reluctant to take on responsibility for someone who may cost a lot of money to provide care for in the community with support. And so even though many of them want to do the right thing, there is a financial pressure on them not to do the right thing. And so NHS England has failed, fundamentally failed, to deliver on what they committed to doing in 2012 to pool that resource in an effective way. Secondly, there is a conflict of interest. The clinician who makes decisions on sectioning of an individual is the clinician who's employed by the provider who's making money out of the use of that bed. Now, I'm an ex-lawyer and I know all about conflict of interest, and if you're a clinician employed by St Andrews or another institution and you're making a decision about sectioning, but you know that the organisation is receiving several £1,000s every week for that bed to be provided, then I think there is a problem, and there needs to be an independent element to the process of decision making that I think still is lacking. I should incidentally say on the first point about shifting resource to local authorities, the result of the failure to shift resource is that there is a lack of capacity of community providers who are able to provide an alternative. And so sometimes, to the best will in the world, commissioners struggle to find a provider who can provide a package that the individual could take up and enable them to get out of the institution. There is also clearly a vested interest. Many of these providers, and it includes some state providers within the NHS, have a model of care. They are receiving substantial sums of money for institutional care, and so there's a group of people who, in effect, have an interest in keeping things as they are, and that, I think, has also been a factor in resisting change. And then I think also there is a lack of legal rights for the individuals and for their families to challenge the model of care. And that is why, when I was Minister, we decided to embark on a Green Paper. We published the Green Paper just before the general election in 2015. We made very clear proposals for reforms to the Mental Health Act, in effect to give more power to individuals and to families to challenge decisions that are being made about them. The brutal truth is that nothing's happened to that Green Paper. It's been sat on for 3 years. There is now a review of the Mental Health Act led by Simon Wesley, former head of the Royal College of Psychiatrists. I hope that that might lead to some change, but it's years off. It will take years to be implemented. So, just to conclude, where are we today? Well, the commitment to achieve a reduction of a third to a half by next March is way off track. There is now a real risk that in trying to hit that, even the lowest end of that target, that corners are cut. Many of you will be aware that transitioning someone out of institutional care into supported living is a complex and difficult task, and it involves often months of planning. The risk is that rushed decisions are made to clear beds, and that there will be then failures of care which will have a fundamental impact on those individuals and will in some cases result in a readmission to hospital. There's one lad called Eden, an adult whose family is in West London. He's been in an institution in the middle of rural Norfolk for years now. There's been a persistent failure of this individual. Eventually they got him home, but without adequate preparation by the local authority, and he's now back in that institution again. And his mother is in a state of total despair as a result. I had an email just a couple of days ago, nothing has changed, and the provider has now been withdrawn from the local authority agreed providers, and so they are back to square one. It's a dismal, dire situation of a man about 30 who's been failed most of his life by the state, I have to say. The final thing I would say is that there is, in places, signs for real optimism. In my own county of Norfolk, there is a service for children and young people called Starfish. It's a service for community service for children and young people with learning disability. They've got an inspiring leader who had worked in an institution but is now completely committed to keeping children out of hospital. And when I met with her, she described how, in her view, there were very, very few cases, if any, where a child needed to go into hospital. And if they did ever need to go, they should go for a short period, genuinely, of assessment and treatment before coming out again. But she made clear that the real risk of an admission is that once they're in, they stay there, and it's then very difficult to get them out again. And she told me very proudly, as I was preparing for the debate that I secured back in July, that in the last year they haven't had a single admission from that service into an inpatient bed. Now that is brilliant, and it's inspiring, and it shows it can be done. And she leads by example to the whole of her team. She described to me how she's, when necessary, stays with the family over a weekend to get them through a crisis. She explained to me that families always want to keep their child with them if they possibly can. But too often there is pressure to admit and a sense that there's no alternative. Well, she's proving that there is an alternative. But the shocking thing is that amongst the data, which shows the too small decline in the total number of people in inpatient care, there's actually an increase in the number of children and young people in inpatient care, which is really disturbing. She is proving that that is not necessarily what has to happen, and she's showing that there's an alternative model that can work. So this is not about money fundamentally, because actually often care in the community with proper support that respects people's human rights is on the whole not more expensive, quite often cheaper than institutional care, which breaches people's human rights in a fundamental way. But transitioning from one model of care to another, particularly when you have the clunkiness of the NHS and the social care system side by side, one free, one mean tested, different organisations commissioning, one under acute financial strain, the other under serious financial strain, no side wanting to take responsibility. This creates an enormous block to change, but it is a change that is fundamentally needed because we are treating people with learning disability and with autism as second-class citizens in this country, and that is intolerable. Thank you.
Norman, if I may, thank you very much. I'm really pleased you didn't keel over, because I'm a social worker, so I would be reliant on other people in the room to assist you. Norman says he's prepared to take questions. We have 10 minutes. So who would like to go first? Yes. Can you identify who you are?
Yes, so I'm Carol Phillips. I'm an independent researcher.
What's your first name again?
Carys.
Carys, yeah.
Carys from Wales.
Yeah,
so
excellent.
I'm the only person here from Wales. There we go.
Excellent.
So the House of Commons Select Committee looked at continuing healthcare. It failed to look at learning disabilities and continuing healthcare. Do you think that's a problem? In your reasons and the failures of post-suitable review, you listed 6 failures, and 4 of them related to money and the difficulties.
Where the money
Yeah.
rests. Yeah.
Given the NHS obligations
Yeah.
of the 2006 reviews.
I mean, NHS continuing care sits at this very uncomfortable margin between a free health system and a means-tested care system.
But the review was blind to this
Yeah.
population group.
Absolutely, and I think that is a failure. I think there's a mass lack of understanding and sometimes lack of interest in this group of people. By way of example, when we got the debate in July, I think there were 3 backbench speakers in that debate. The chamber, I mean, there were some awful pictures on television, on social media of the chamber, but it was pretty much empty. And most people don't begin to understand what this is all about. The families are left to advocate on their own, often, and often the MP doesn't know what to do with a family that's come to them with a complaint. So nothing happens, and there is a responsibility on select committees to seek to understand what these barriers are that need to be removed. We have to remove these really clunky barriers if we're to change this model of care.
So the NHS is 70th year and it's completely privatised learning disability services, really, isn't it?
Well, I made the point earlier that there are still quite a lot of beds in the state sector. Interestingly, I mentioned Merseycare. They've taken over Cornerstones, which was the only dedicated learning disability trust in the country up in Lancashire. But it's predominantly private and third sector beds. But in my view, wherever the beds are, whether they're public or private sector, human rights abuses are unacceptable, and depressingly they happen in both sides of the divide. Just think about Colin Sparrow, a boy with an adult with learning disability and autism who lost his life at the care of Southern Health. So, you know,
and that's about moving the resources from.
Yeah. Well, I mentioned this sort of vested interest that is very powerful in my view, which stops change happening. But it covers mental health as well. I visited a hospital, a private hospital in my constituency, which has recently been established. This is a mental health unit, and the guy who owns it described to me how his ambition was to get up to 100 beds in this private mental health unit. Now, the only way that will succeed is if there are out of area placements from around the country into his facility in Norfolk. And I explained to him the national policy is to end out of area placement, something I also feel very strongly about. He is relying on national policy not being delivered. And it's that awful sense that people are making massive investments in the wrong model of care.
Yeah. Apropos of national guidance about housing authority and placements, amongst other things, I write safeguarding adult reviews, as do a number of other people in the audience. And one of the things I found in some of the reviews I've done is that the practice guidance issued by CCGs nationally and by ADAS, whereby placing authorities have to inform receiving authorities, whether local or CCGs, of placements being made not being followed. And
so they often don't get involved at all.
Absolutely. And I think what would be really helpful in the next iteration of statutory guidance, if you were able to influence it, is in fact a binding statement on CCGs and local authorities that if they are placing outside of their boundaries, and a receiving CCG owner of water must be notified in order to take that individual on board in terms of receiving proper care, which you're quite rightly advocating. Anyway, enough of me. Yes.
Just to speak to that point, I work in the City of Anglia CCG and we do make an endeavour to do that, but there's not really a very clear mechanism. Some CCGs, the method is that you would email an admin person who keeps a spreadsheet, maybe on a computer. I've done that and got many out of office reports. We had a letter from Cornwall CCGs asking us to make sure that we tell them who put in there. So we have panic, do we have any Cornwall? I don't think so, whatever, you know. There is no sort of online reporting mechanism. It's reliant on human beings and desktops.
Yeah. Well, that you've described precisely how it's failing.
Yeah.
That clearly needs to change. I mean, any of you, if you want to put this in writing to me, I would gladly put it to the ministers for consideration. But of course, we also need to be ending the practice as well, sending people continue out there.
Paul had his hand up, but I think you also had your hand up.
Yeah, hi, it's Abby Scully and I work for Suffolk County Council Public Health and I lead on the safeguarding for public health there. I'm just wondering about the leader, the leader programme. Do you think that could be used to influence how we purchase those?
Just remind me the leader programme.
This is the learning disability reviews.
Right, yes, okay. Yeah, absolutely.
Now has to be
the mortality reviews.
Yeah. Yeah. Do you think that could be used in any way to positively change how we commission beds?
Well, I'll tell you the failure, I think, at the moment with LEADER is that, which is fundamentally important, and I was involved in getting it established in the first place, but nothing happens with the outcomes of those reviews. They sit in the ether again. There needs to be, again, a mechanism of learning so that, there's no point heating the atmosphere, spending a lot of money reviewing things if nothing ever happens as a result of it. That's what tends to be the case. Absolutely could be a mechanism for driving change.
As can safeguarding adult reviews.
Yeah.
The same critique and the same.
Well, the coroner's inquests, those recommendations get ignored as well.
I think it's just to reinforce that we made Michael that these are area placements, so that as far as I'm aware, there is a duty to ensure that placement is a standard of quality that stays out of the CCGs. Yet they're fairly miserable to exercise that responsibility. It's not going to change in short term. What we can do is force the CCGs to take that responsibility more seriously. If you could put that in some legislation, please do so for us.
Sadly, no. I just have to shout from the margins. I've been put back in my box. It's effectively what's happened. But I can make representations. If you give me the bullets to fire, I can do them.
I was going to invite you to hypothesise. I know politicians don't generally like to hypothesise, but if in a world of the future you were to become Minister of State again, what might be your top priorities in relation to adult safeguarding or transforming care, about which you spoke to?
Well, I'm one thing that I am acutely aware of is that in my time as Minister, I was there from 12 to 15. I learned the extent of power that you have at your disposal, and you learn how to use it more effectively. And some ministers from all parties get into a ministerial position and do nothing, are sort of passive. Some have a reforming agenda that they want to pursue, but doing that in an effective way is the challenge. And I learned that implementation is just as critical as the ideas in the first place. And with transforming care, and it's in a sense held back fatally by this divide between NHS and social care, in my view, which ultimately I can't on my own influence, but you need to find mechanisms to deliver what you want to achieve. And if you don't, you won't achieve it. But fundamentally, I think that our system abuses the human rights of people with very disability, autism, but also people with mental health. We still rely on an institutional model of care. We have longer lengths of stay than many other comparable countries. Here's a statistic for you. In CAMS beds, children and young people's mental health beds, the average length of stay in England is 72 days. The average length of stay in Australia is 10 days. Now, I think we positively damage the health of many children who put into long-stay beds, often away from home. Just imagine as a 15-year-old trying to reintegrate with a group of friends in your school if you've been in a bed 100 miles away from home for 72 days, or in many cases worse than that. So I think the model of care is wrong, and I think we abuse people's human rights, and I will be on a mission to change them.
Ladies and gentlemen, would you stand for
Thanks very much for inviting me today. As you can see, it's bringing together a lot of things called Circle. First of all, I always like to start off by talking to people and saying a really big thank you to anybody, and I know there are people in this room who've helped with some of the research we do. We do quite a lot on safeguarding, and none of it can have any value at all unless it's informed by people like yourselves in this room, and obviously people who've been affected by safeguarding in families and communities. But without people taking the trouble to fill in really annoying surveys and do an interview when they're desperately tired or busy, we wouldn't have the quality of the evidence that I think really is the hallmark of safeguarding in the UK now. We have a lot of evidence, and when we look globally, we are rich in evidence, and we just need to make some use of it. So thank you very much, and to apologise in advance when I trouble you yet again with some request at a very difficult time. My presentation follows so neatly, doesn't it, onto some of the things that have happened today. Partly because Norman Lamb has talked so eloquently about two powers of access. First of all was his power of access as a minister. None of us, I think, in this room can probably insist that we go and see people. He had in his person a power of access, and how valuable that was. And he was going into an institution where things are perhaps a little bit more open than in families or in neighbourhoods. So that was one telling moment about how useful he found it. And the second was his discussion, I think, very reflectively about the dilemma that policymakers faced, and so the civil servants at the time, about dealing with something called powers of access or powers of entry. So, turn over page 2. Right. What we did in the study that I think a lot of people think that researchers sort of get given things to do. Well, yes, we do sometimes, but there is also a lot of negotiation, because part of the trouble when you're doing research is that there's an idea around at the time, and you have to make sure that you're not just repeating that and that another study hasn't been funded. But it had been something that had been on issue in conversations with people about difficulties of sort of getting in there, and particularly in the community, and when people contrasted that to the greater powers that you had if you went into a care home or a hospital or a prison even, it was actually getting in over the threshold to find out whether concerns were justified or not. And we conceptualised that as a matter of being hindered. So it was not, that was trying to choose an unemotive term. It was also a term that appeared to have resonance with people, sort of people knew what it meant. It wasn't big emotive that we're going to rescue people, because rescuing the elderly has, I think, dogged safeguarding for too long, but we just wanted to find out. And hindered appeared to be there, and it could, and we talked about third parties. Really meaning relatives, but sometimes not relatives, sometimes people who are paid carers or paid to be there, or sometimes our new phrase now was cuckooing, which I think was very useful as well. People who sort of wangled their way into the homes of people and sat there like a cuckoo, hoping to inherit the tenancy or something like that. So hinder is the word we used, and we also used the word helping, because as well as finding out what's bad, you usually want to take a more appreciative inquiry approach and say, well, what works? And you and I know that there are some people who can get into places, aren't they? They often work for outreach teams. They're usually terribly bad at some parts of their job, like paperwork or washing their cups or something like that. But if you want somebody to get into somewhere, you know that person who will get into there much better than perhaps you or I or anything like that. They haven't just got the gift of the gab. They've got some emotional thing that people say, oh yes, lovely to see you again, and you've spent the last week trying to make a contact. So we wanted to take those two phases of this study and work out what was happening. And the Care Act and the Care Bill provided what we call a policy window to think about these issues. And those of you with histories in social administration will know that safeguarding has been driven quite a lot by that concept of seizing the policy window when it opened. When there was concern, often based on scandals, and that's a policy window, a bit of a negative one. When things happen and everybody else is dealing with them, a response to European law in terms of dolls or something, that is the policy window. Policy doesn't just happen, it has to find an area to be there. Oh, there's an overhead. My overheads were designed to be really big, so I'm really sorry that they're quite small on this room. But you can see that when you have an idea, taking it through into a study is usually about grouping it up into the type of methods you want to do, who you can find to help, how much time you've got, and also how quick is the pressure needed to deliver the result. So, as usual with most studies, you do a review of the literature, which I'm sure everybody in this room has done until they're pig sick of it, but we decided to do that, particularly taking into account the international dimension of it, because this isn't a peculiarly British problem. Powers of access happen all over the place. People are always talking about shall we, shan't we, who's going to get it and whatever. In the UK, we probably have resolved some of that issues about powers of access into long-term care facilities. Prisons have slightly opened up, and you'll know there have been developments in things like Health Watch if you're working in an English setting. So that area is less contentious than the real privacy bit in which people talk about the home as being the private sanctum. So we also looked at the DH consultations, and this is the day when it was the DH, when they had done a consultation around issues like powers of access. And every time you feel that, oh, I can't be bothered to respond to a consultation, do remember that somebody like me and my successors will be looking and reading with great intent what you write. So please do send in responses to consultation. They do count. And you can see how the DH analysed them. In this particular bit, they sort of weighed them in various percentages. But every single person who wrote in to that consultation, their replies were read many times. And we sometimes think, well, it's casting a letter in a bottle into the ocean, isn't it? But do persevere, I think, as people would say. We also looked at parliamentary debates, which are, you would think they were state secrets, wouldn't you, parliamentary debates? Because almost nobody uses them to find documentary evidence. It's really easy. I shouldn't tell you this. You really should think that it's incredibly difficult, and you have to go down into Westminster and look at ink-stained parchments or something like that. It is so easy to look at Hansard nowadays. I did my first degree, a first degree on, what was it called, the Christmas bonus. Anybody remember that? And I had to go and read Hansard to see why somebody said old people need a Christmas bonus from the government, which was another matter. Today, to look at the Care Bill thing, just flicked a few tweets, and there was every debate about powers of access talked about eloquently. It was interesting to see who commented on it, who was responding, whether the debate was in the House of Lords or the House of Commons, what was the role of the committee, and just generally working through those processes. And how influential other voices were. It's quite, for us academics, it's absolutely very salutary to realise that almost no politician quotes research. Absolutely no need to bother doing it anymore. What they quote are voluntary sector groups, very much more. This is the power of influence. So I suppose as researchers, and maybe as service providers, to get the ear of government sometimes, do use voluntary groups, because they have a very powerful conduit. If you're the Alzheimer's Society, or your MenCat, or your Mind, or whatever, they maybe have the ear of politicians much more than researchers. And maybe that's because we write such drivel and we use jargon all the time that nobody can understand what we say, and that we'll discuss at another moment. We did a survey, a very small survey of adult safeguarding managers, and just because I think those now represent to a lot of us the sort of fount of wisdom locally. We know there's loads of people working on safeguarding in local authorities, but somehow or other, what used to be called adult safeguarding coordinators, people remember that? And now they've become managers, and they'll soon have another title, very much bringing together local experience, multi-agency experience, the views of the wider board and the wider subcommittees. So a huge wealth of intelligence in there. At the phase 3, we chose 3 local authorities and went into them and talked about practice. And if you work in England, you know that there are 108 local authorities or whatever it is, and each are genetically different. Everybody who works for a local authority will claim to be different from any other local authority, is that right? And that they do things the way they do things because that's the way they do things in that local authority. So we chose 3 very different ones, and that was very, very helpful because clearly place and context matter, don't they? If you work in an authority with almost no care homes, your view of the world is very different from a place where there are large numbers of them, or you've got long-stay hospitals or anything like that. So important to know context matters. And then lastly, we did have interviews with safeguarding and social work managers in particular, social workers on the ground, and also as many disabled people and carers as we can get. And it is really important, I think, in any work we're doing now, to hear the voices of people who are classed by some people as vulnerable. It is, of course, really difficult to get people who've been what they call through safeguarding. We know that from a lot of research which has said that people who've been through safeguarding, they're usually very poorly. Often people have died en route, not because of safeguarding, but that's how poorly they are. And a lot of them have very profound communication problems. So to take a proxy view of carers and people who've got vulnerabilities is important. I'll do that too, remind me. So what did the care bill say? And it was so interesting to remind ourselves of what was in there. Norman Lamb reflected so well that bit that there were strongly held views about a power of access, that people were going to break down the doors to rescue people who didn't want to be rescued, do it inappropriately. All those voices were heard, and particularly among disabled people who made that case that they had a right, the human right was to a private family life, not necessarily to state intervention. The Department of Health did this consultation, it got the submissions, it did them in various percentages. As you can see, only 18 members of the public, quaintly called, were in favour. 72% of social care, which actually wasn't all local authorities, and indeed a very high percentage of health professionals thought that a power of entry would be helpful. And I think we have often missed out what their experience is, particularly community nurses, of managing those threshold encounters. Some of them are very good, but a lot of them do find it quite difficult. Small numbers of people said that it would be unjustifiable, and it was about proportionality, and a lot happening at that time. One of the useful things we did was to look at think tanks, which are the other contributor to public debate at the moment. And a lot of them, particularly those on more the Conservative Party side, had a lot to say about infringement of human liberties and state intrusion. And sometimes it's a Guardian reader, you only read what the Guardian says, or something like that. And it's really, really important to look at those alternative views. So, continuing debate. The subject hasn't gone away. Action on Elder Abuse continued to say both that elder abuse should be a crime, obviously elder abuse is what they're about, but so do a number of other organisations around safeguarding adults, and that they continue to say that a power of entry to speak to a potential victim is important. So as well as access then, we've got that second debate about what do you do when you've got over the threshold, and what do you do? And the notion is that you have to speak to that individual, hard as that might be. We of course were influenced by what is happening in the wider UK. Oops. Anyway, I think I've summed up what's happened in what was happening in England. In Scotland, there were various, I think that's on the paper here. Scotland, the well-known but little used Adult Support and Protection Act We've tried to get the figures on the use of that, and strangely enough, they're really, really hard to do. We've got some early figures that I think Michael Preston-Shute and colleagues helped grasp, didn't you? But that has not been succeeded by any figures. We don't know whether that was a blip that you got into the homes of all those people you've been planning to get into for years and years and years, and then nobody else left, or whether or not it's going to be a trend in which you say, well, I did 10 this year, 100 next year, 5,000 the year after. We just don't know. That makes it very, very difficult to compare. And always the rule in research is, be careful of comparing pilots, because pilots are always very different, or the early adopters of something, with normal practice. It is never normal when something is introduced. It's always a bit odd. Keep on. An 18-month principle, I think, works very well. After something's been in 18 months, then look, then see what's going on. The trouble is we haven't got that yet from Scotland. It will be very interesting when we do, and to have that dialogue with Scotland about what are the particular cases they're finding it important. Wales, we're going to know a lot about them as well, and Northern Ireland, as Joyce here from Northern Ireland has assured me that there is no power of access, partly because there's no legislation. Northern Ireland has its own lack of policy windows. So, internationally, you probably don't know about Singapore, I'm hoping, because I'm just about to let you know that in Singapore they have got a new Vulnerable Adults Act. It's a bill, really, because it's been passed, but it hasn't quite been implemented. It's like the Green Paper. They have promised it for the end of the year. I'm sure being Singapore, being much more organised, the end of the year means the end of the year, whereas Green Papers in this country can be a variety of timings. So Singapore is interesting because Singapore's law is very, very similar to ours in respect of our Mental Capacity Act. If I showed you the Singapore Mental Capacity Act, you'd say, well, that's the same as ours, and indeed it is. They don't have to worry about plagiarism in the same way as we pinch lots of our laws from other jurisdictions as well. They, though, were influenced and have adopted a power of entry, and they've taken their lessons from Scotland and also from Canada, and particularly New Brunswick, to say that this is what they wanted to happen. And as usual, as well as Hansard, you've got what ministers say as being so important in legislation, so the ministers saying why they have chosen to adopt this. Singapore isn't a greatly abusive place. It's and in fact it talks about an ageing population in a rather quaint way when we think about an ageing population, because they might get into double figures or something like that. But it is a place in which they take the rule of law quite seriously. And I think this reflects it in this piece of legislation. They have thought about it, they've consulted internationally, they listen to our debates as well, and about the way in which that decision was taken here, but have chosen the path of Scotland and Canada. And again, that will add richness to it, won't it, in terms of cultural issues, because clearly family in Southeast Asia is so incredibly important still, both as a provider but also as a very important part of their culture, that we'll learn a lot from them to intervene. So, our study, what did it show? It showed a variety of things which were particularly around what did you want to do once you got over the threshold. And people wanted to have a private interview. This was the whole bit. The bit wasn't to get into the house. It was to conduct that private interview, that assessment, that communication with an individual on their own. And of course, they found that it wasn't necessarily to get into the house. You had to make sure that the individual felt you could have that trusting conversation, and it wasn't going to leave them in a worse predicament than when you went in. Very hard to manage. And what I suppose we're really thinking about is that this was street-level activity, street-level bureaucracy, as it's sometimes called, the way in which individuals would manage that and would retreat, even with given the power, if they felt that that was adding to the potential for abuse. Some of them wanted assessment orders, so that was able to say that legally we are going to do an assessment, not about judging people or anything like that, but having the power to assess. Very few of them wanted the power to remove. And it's quite difficult, isn't it, that if you've done the conversation, you have assessed, if you haven't got the power to remove, what do you do? In Singapore, they have adopted all three of those. There is a power to remove, and a person will be detained in a gazetted facility, which sounds very odd, but really that's just the name that they give to registered facilities like nursing homes or a very, very large hospital. So what do you do when you've got that power? The over the threshold incident. We then asked ourselves, how would we estimate, and what would professionals say was the estimate of the problem? Because a lot of people say it's a big problem, but they mean that's a big problem to me. They don't necessarily mean I've got 1,000 cases like it. And the trouble with safeguarding is we have absolutely no data on the size of this problem, so we were reliant on guesstimates and people's memories. So you can see that no survey respondents said that they collected data on it. So actually we just don't know. It may be that one case dominates everything and people refer to it numerous times. When we asked a local authority how many cases they got, we had a range from 0, we have had no cases, to 70 cases. And these were not totally different local authorities. It was just their guesstimate of what was going on. So we just don't know how big the problem is. In most cases, people said they did get in. It was difficult, they had made compromises, but there were very few cases where actually they did not get in. But they had got in, and it may not have been the best procedure, but it had happened. And then lastly, what they remembered was that these cases took a very long time, they involved huge numbers of people, loads of meetings, and they were quite onerous for the individual worker who would go back, worry themselves sick that something was going to happen, always feel stressed about the case, was seen as being rather inadequate sometimes because they hadn't managed to get in. They added to their stressful jobs. And that, I think, creates a big problem. We didn't do any cost estimations because we didn't have the data, but clearly you could do things like asking people to add up the hours that had been spent on various cases and trying to see whether or not these were incurring substantial costs. And you know, it's a bit hard to talk about costs when you're talking about individuals in very distressed circumstances. But when we are living in that world of saying there is something that has to be collected around costs. So as you can see on the next page, which I'm rapidly going to show up, that's that page. What we've got is not very much in advance of the arguments that were being discussed around the care bill, and probably even before that in the white papers that have littered the landscape in adult social care more recently. The key thing, I think, as well as all this list, and you can see here, they list the advantages, the disadvantages, is that the debate has moved on around coercion. Coercion has been named much more than it has been really recently. If I say coercion, we all have an idea of what that means. We know that it exists, we know it affects people's capacity, their communication. It is the new bit, the new concept that is right is coercion, and the way in which individuals are looked out for it. And as people will know, I'm a great fan of the Archers, which was, of course, the first place to recognise coercion so dramatically in British life. But I think, really, Helen's story in the Archers just shows that power of coercion, doesn't it? And if it's reached the Archers, well, clearly it's in the national psyche, isn't it? So be aware there. Much similar, familiar arguments. The other three things, though, that we have not done too much around is about that notion of privacy. And privacy, I think, gets wrapped up in human rights. However, it is not very easy to find privacy. I've got a doctoral student at the moment, and we're working on where is privacy. And it gets buried in dignity, in a sort of funny way. And privacy and dignity are sometimes used interchangeably, but just look out for privacy, because we think we know what it means, but I think it will come up as what are we meaning by privacy, as a sort of socio-legal term, a very emotional term, and it's to do with humanity, isn't it? But also the differences are changing about what is privacy. And we are in a fortunate position in the UK, which some places aren't, of saying that when we have things like, when we have facilities like care homes, usually there is some privacy. There's still many, many parts of the world whereby you share a room if you're in a long-term care facility. So just thinking of and being observed about how privacy is being blurred in many respects. The second one is the notion of vulnerability. And the notion that we're all vulnerable, aren't we? Nowadays we're all vulnerable to hacking or whatever it is, but we are all really vulnerable. And how we're still playing out that notion of people being particularly at risk, lacking capacity, where their vulnerability lies. And of course we know on the research on perpetrators, as the lady over there asked about, that many perpetrators, if you use that term, are vulnerable themselves, and its vulnerability is very hard to pin down, and I think is one good reason why we've tended not to use it so much in adult safeguarding. And the last phrase that we've been thinking about is autonomy, and I've listed up some there, the notions that are around Mental Capacity Act, but also around the deprivation of liberty safeguards, about that mixed picture of autonomy. And then the slide after that is saying, has all this stalled? Which I think it probably has. That we haven't really got a policy window at the moment. We space ourselves having that old debate, what's the difference? What should we value? Autonomy or protection? Are they the same side? Are they two sides of the same coin? And the debate particularly continues to go on. So moving to, because time is whizzing by, our conclusions. Research has never come up with anything really conclusive, do they? It's always a bit of this, a bit of that, and so here are mine. Complex hinder situations are rare. They are memorable, but they are rare. They are resource and they are risk intensive. And I think that's what we've learned about them. So they're good to discuss in multi-agency ways, to discuss in supervision, to do that reflection, because they often crystallise a whole area of debates and practice. What we found, interestingly, was that there were approaches, different approaches, taken to people who were known to services. So we know that family, we know about that, they're down on the books, they've been around, as to the total new people who've suddenly gone, oh my goodness, we know nothing of them. Has anybody got any records? They've suddenly arrived as if from Mars. And that was an area of practice that we hadn't expected to find out, that difference between known and unknown. And I think Maria, who's sitting in the audience and talking about self-neglect, may find that too, that if you're known or unknown, it does affect the way in which agencies respond. We listened a lot to accounts of practice wisdom. And, you know, how are you going to get practice wisdom if people are hot desking, remote working, or whatever? Is it going to sort of transmit with your email or anything like that? I think we will regret some of those processes in which that opportunity to discuss things has gone away. We have continued aspirations for guidance. Everywhere somebody says, what I'd like is more guidance and probably a policy on top. Nobody, when we said what helped, said, well, I picked up that policy and do you know it told me exactly what to do? Of course they didn't. But when you ask people what they need, first of all they need training, the next they need policy, the next they need guidance. But actually is the evidence is that they don't use them. They are not fit for purpose, and maybe they are they just don't fit the situation that people are in. People need skills, they need mentoring, they need all those sort of approaches, and guidance possibly doesn't solve that. And then lastly, as you would expect, I would say we need to define the size of this better, because rare situations mustn't govern what we do all the time. That's not appropriate. The scale of it matters, and what actually we're talking about, and the shape of what we're doing, I think, will change, particularly around dolls and any changes to the Mental Health Act. So as usual, I've got to thank all of the members of my team who did really all the work. As always, thank you for listening. If you want to read anything, there are copious publications from this, including one chapter which focuses on this issue as reflected in safeguarding adult reviews or serious case reviews. And then, as usual, I've got to say that everything I say is entirely my opinion and not that of the government, or the NHS, or the NHR, or even probably the participants, but to thank you very much for listening.
Thank you very much, everybody, for staying. I know that the temperature's going up in the room, and if I look like I'm around to build, it probably is because I'm but there we are. Alex and I have not discussed how much time we each have, so my intention is to finish at 5:22. That means this is a bit of a whistle-stop tour. Those of you who have looked in your packs will see that I have got a lot of slides. What that means is that I'm not going to go through all of the slides. I will be saying next slide, whatever. those of you who know me or know me by repute will know that I'm quite happy to have people contact me. And when I was thinking about having less time than I'd originally thought, then what I was also thinking was, I'm going to leave these slides in because you never know, somebody might want to have a particular beside me. So, next slide please. My task this afternoon is to say a bit about the Convention on the Human Rights of Older People, which is currently being discussed at UN level. But when I started thinking about this, I was reminded of a piece of work which took place a very long time ago, early-ish in my days in safeguarding, particularly around elder abuse, and it was with the International Network for the Prevention of Elder Abuse, who undertook a piece of work in 8 different countries across the world, and what they were looking at was trying to gain perceptions of older people about what abuse was, and also perceptions of professionals. Now, one of the things that was interesting in that piece of work stands right in the middle here, and it's about violation. What older people were saying loudly and clearly in all of the countries that were visited, and they went across the world. The 2 European were Sweden and Austria, so it's a little bit of we weren't included. But they talked about violation of human, legal and medical rights as being part of what they considered to be elder abuse. Next slide, please. Sorry, I was busy writing. So some of the key points that I think we need to take into account in elder abuse generally are that abuse and violence is socially constructed. What we understand and consider to be abuse and violence changes over time. It depends what society you're in, depends maybe what community you're living in, but it does alter over time. And it's not just about family and interpersonal relationships. What we understand very fully in our roles in safeguarding is that institutional settings of all sorts are really very important here. It's also not just about frailty, vulnerability and dependence, but we've got those different levels at which these situations occur. So we've got that micro level, the personal, individual level, maybe between 2 people. We've got the middle level, the meso level, at the community level, and then we've got that structural social level beyond. And I think, and this is me of course, being the sort of person I am, that we know that throughout many societies we've got very high levels of ageism. Ageism directed towards older people. And I think that gives us a backdrop, what I call as a master category, perhaps I probably would not use the word, but that's the sort of central point. And abuse, in some respects, then is a consequence of that. Next slide, please. What we also know is that there's been quite a lot of silence about this topic generally. Until the last few years, and I can tell you this because I've been around for very many years, there's been really quite a lack of recognition about the issue generally. Issues in relation to elder abuse, but also other types of abuse and violence. And to that extent, it's been a sort of underdeveloped and under-researched concept. But I think one of the important things for us to remember and to bear in mind is this very bottom point here, that actually professional identification of the issue as an issue is very important. And what we know is that it's similar for elder abuse as it was for child safeguarding and child protection. It was first professionals who identified this as a potential problem and said that something should be done about it. And that's really quite different from the situation in relation to violence against women more generally. So, we have shaped policy and responses because of our professional identification, because it wasn't out there in the public. Can you skip 2 slides? Thank you for that one. So, elder abuse and human rights. This is an area which has gained traction in the last few years. Initially, people talked about elder abuse as a social problem, then they talked about it as a public health problem. Finally, somebody twigged to say, okay, this is a human rights problem. Back in 2002, there was the second World Assembly on Aging held in Valencia. And for the first time in that sort of forum, we had neglect and abuse and violence contained as an element as being a priority area for action. It was seen as both very centrally a public health issue, but also a human rights issue. And what was talked about in that forum was the fact that there was decreased quality of life and hastened mortality for many older people who experienced abuse and violence. Next slide, please. So the recommendations that came out of Valencia were that older people have the right to live life in dignity and security, free from abuse, neglect, exploitation and discrimination. And furthermore, that governments should develop and fund national comprehensive strategies and action agendas, action plans, in order to tackle this issue. And that there should be clear strategic direction. This is a long time ago, we're talking 16 years ago, and really it sort of swung around in the ether, but it didn't go very far at that particular point. Next slide, please. So there were the normal additional recommendations: public and professional education and awareness, participation of older people, and I'll come back to that slightly later, a supportive legal framework, and that the UN Commission on Human Rights should appoint a special rapporteur on abuse of older people. And again, I'll come back to that. Skip 2 slides, please. Valencia statement was a statement that came out, but I'm happy to skip that at some point. In relation to non-governmental organisations, however, they were given quite a strong steer by the UN Secretary-General report from the same year. So what he said at the time was that there were 4 key areas in which NGOs could assist in this matter. So they could promote and enhance awareness about abuse, they could lobby for policy action and legislation, and of course a number of them have been doing so consistently ever since. They could promote and provide services and assistance, so guiding and supporting strategies and programs, working on prevention. But, as I said, nothing much happened, and then we jumped forward to 2010, when a UN Convention report came out for strengthening older people's rights towards a convention. So this was actually bringing it back into the UN sector and saying there needed to be action. And this was a document that was put together by a group of NGOs, and the notion was that it would really start a renewed push to have action in this area. And a declaration was made at the European Economic Council in 2012, which was really about reaffirming the rights and obligations of states to protect and uphold rights of older people. So what there was also at that time was an attempt to sort of draw links to what was developing in relation to the Convention on the Rights of People with Disabilities. Next slide, please. So the focus at that time was to reject age-based discrimination, protect your rights by enforcing existing legislation, promoting good practice that would help older people to understand and claim their rights as rights holders, and then strengthening the legislation that existed at all sorts of different levels, national, regional and international. And again, with sort of emphasis on including older people. Next slide, please. So in 2011, the UN Secretary-General, in his report to the General Assembly, so this is a much wider frame, it's not the Human Rights Council, but it's not the World Assembly on Aging, it is actually the UN Assembly, focused on the human rights of older people. And you'll see my little bracket saying first, because it was the first time it had been mentioned in that arena. And what he said in that report was that there were 4 main human rights challenges for older people: discrimination, poverty, violence and abuse, and a lack of specific measures and services to support people and to assist them to claim their rights. So, of course, NGOs around the world stuck up little flags and said, yes, yes, we're going to get somewhere. And it didn't actually go terribly far, but in the next slide you will see that, he very helpfully in his report outlines some of the areas where action could be taken. So strengthening the international protection regime, eliminating financial exploitation, music to our ears of course, elimination of employment discrimination, and care and support facilities, and that this should happen at all the different levels that exist. So, local, regional, national, international, that should all happen. Next slide, please. Now we come to the bit about independent experts, because independent experts they're not quite like special rapporteurs, they're a sort of tier underneath, because special rapporteurs tend to exist when you've got a convention. There's no convention that exists at the moment in relation to all people, but the Human Rights Council have set up this system of independent experts. They're not members of staff of the UN, and they're not paid for their work, but they get expenses, because part of what they do is visits to different countries to assess people's attention to rights and to looking at obligations for groups. And they express their views independently, so the reports that they produce can be pretty damning of what's happening in particular countries. And what they actually decided, next slide, let's get again, is that there should be one in relation to older people. So from 2014, the Human Rights Council, based in Geneva, made an appointment. The current person in that role is a woman by the name of Mate from Chile, and she has just been reappointed to her position for a further period of 4 years. So she started out in 2014, and her background is in a number of different areas. She's worked in government, she's been policy making, she's worked in the health sector, she's also worked in the university sector. So she's got a broad range, but her focus has always been on older people, and very well respected in her field. So her initial report back in 2014 to the Human Rights Council was of her initial preliminary observations, and basically what she was saying was it was a pretty hard state to be globally. She's done a number of country visits. She's been averaging at least one a year, but in some years, I guess probably if they're smaller countries, she's been to more than one. So Austria, Mauritius, Georgia, she's recently been to Slovenia and Montenegro. And then she produces the reports and she makes statements to the Human Rights Council, which actually meets on a pretty regular basis, at least twice a year in Geneva. What she has also done is she's produced separate reports on specific issues. So in 2015 she produced a report on autonomy and care, which is very accessible, very readable, available through the Human Rights Council website. And she's also more recently looked at the use of technology with older people and issues around the use of sort of developing robotics to assist older people. She does annual reports to the council, and her mandate was to produce a comprehensive sort of global report in 2016, which she did. Next slide, please. Now we come to the open-ended working group on ageing. This is led by the Committee of NGOs on Ageing, and they're the lead group in this open-ended working group. They were established back in 2011, but it took them a little while to get going. So all the NGOs that are accredited by the UN got together, and they pushed to have this open-ended working group looking specifically at issues in relation to the Convention on Human Rights. They meet approximately annually in New York, and what they've been looking at consistently across the years is they're looking at the whole notion of having a Convention on Human Rights of older people. What would it look like? What might it contain? They got a bit stuck for a number of years looking at where the gaps are, what are the gaps in protection for older people, because one of the very commonly stated things is that the Convention on the Rights of Disabled People actually does the job and would be fit for purpose for older people. And of course, what member states, etc., keep being reminded about is that there are a large number of older people who are not disabled and who will not be covered by that particular convention, although others might be. But of course there are some discrepancies NGOs and representatives from NGOs. I've been privileged enough to be invited there by an NGO on a couple of occasions now, but there's also member states, and it's held in a great big room, which is a bit overpowering because the member states sit in the middle and the NGOs sit at the side, and you sort of feel like any minute now someone's going to lob something. But there's a very specific process that has to be followed. So, there are statements from the front of renowned experts, and then you come to the member states making their statements, and then they say, okay, NGOs can make their statements now. They have looked at some specific topics. For example, in 2015, they looked at older women, and what they also did from last summer, they decided to take specific topics. They've been talking about gaps and they've been writing lists of where the gaps were for quite a while, and then they suddenly said, okay, let's take 2 topics a year and look at these in depth. The first 2 topics that they chose for 2017 were equality and non-discrimination, so issues around ageism fit in there, violence, abuse and neglect, which was a big surprise to me because I thought it would be way down the list. However, we talked about it, and then this year, the further topics they looked at were autonomy and independence, so around decision making, etc. Also long-term care and palliative care, but there was a session where they actually looked at what the normative elements, what the elements of conviction in relation to, for example, violence, abuse and neglect might look like. What would it have to cover? Next meeting is July 2019. The topics that have been chosen, selected, and this is member states who choose them from the long list that was produced, are lifelong learning and education and social protection. So I'm waiting to see if I get another invitation. I may or may not. One of the things you may be interested in, or may not, but it was an interest to me, was that actually, government-wise, the portfolio for this rests with the Foreign and Commonwealth Office. It's the equality section, and they deal with this. So they have briefings. So I have been invited, Alex has also been on occasion, to brief them about the different topics, and then they produce their statements, and the NGOs also produce their statements. Global Alliance of Rights of Old People is a group of NGOs, and people who belong to NGOs should encourage them to get involved with this group, because they issue information about what's happening when the meetings are, they ask for submissions to be developed, and it's a growing group because there are more and more NGOs which are becoming interested at a global level. They're based in the UK, which obviously means that we have good access to them. So it's a combined thing which is run by Age International and Help Age International. 2 separate groups. Age International is an offshoot of Age UK, but they're centrally involved. Next slide. I just thought I'd put up some reminders for us, and of course the glaring one is missing off the bottom because I added it in, and then I hadn't put it on the slide I submitted. And the one that's missing from the bottom, of course, is that just like our NHS is 70 years old this year, the UN Declaration on Human Rights is also 70 years old this year. Age Platform, which is the umbrella group for NGOs across Europe, so Age UK, etc., are signed up to them and are affiliate members. They are running a campaign at the moment around ageism, and there's going to be a week of activity in mid-November which will be focused on violence, abuse and neglect. So those of you who might be interested, please do get in touch, and I will send you various information about how to follow what they're doing, what they're producing, and how to get involved. I think I better stop here because Alex needs to start. Thank you very much.
I then was here for this afternoon, and I just want to try and talk some of the things that he was talking about, some of the things, respond also some of the things that Norman Lamb and Jill Manthorpe were talking about in this area. And if you want slides, the overview of what they cover, it's really along the theme of there are a whole host of things that we've now got to recognise that we have coercive and controlling behaviour in relation to one cohort of adults. Those adults who are in intimate relationships. And what's bothered me for quite some time, and I was really actually hoping I'd be able to report on this at this session, this was going to be an actual outcome of this seminar series, because it was over the life of this seminar series, me trying to agitate to get law reform in this area, which has gone spectacularly nowhere. And we might just want to be, you might want to think about why it's gone nowhere and whether or not you're happy about the fact it's gone nowhere. But it came from me being very exercised about the fact, and actually the very first seminar was really interesting discussion on how there was a recognition now of domestic abuse. There are a set of tools and a set of thinking and a set of recognition and a naming, as Bridget said, in relation to older persons. The idea of a naming. But there was a great cohort of people who fell outside that, who were subject to similar sorts of coercion, exploitation, abuse, physical, violent, emotional. And I come across this in my professional practice as a barrister. So I'm skewed, Jill. I see the difficult cases. And they take up an awful lot of time and they're very, very difficult. So I was bothered about that. The other thing which bothers me no end, we'll talk about this in a minute, if you have somebody who is said to have capacity and to be subject to coercion and control, but outside the zone of the Archer's offence, coercion and controlling behaviour within intimate relationship, you have to run off to court, if you can, to go and exercise the inherent jurisdiction. And one of the things which is really frightening about the inherent jurisdiction, you have absolutely no idea what the judge is going to do. None. It depends entirely on what the judge feels like. If you come across someone like Sir Mark Hedley, you are likely to get something extremely empowering out of them. And you're likely to get relief directed against the perpetrator. If you come across a different judge, and Mrs. Justice Parker say, she would be prepared to order that someone with capacity be deprived of their liberty in a care home away from their rubbish husband, with capacity. Those are two very, very different people, two different judges exercising great power. Well, Sir Mark's right that judges have to explain what they do, but you don't have any written framework, any set of principles against which they can be judged and they can be held. So that's where I came from, and I was very exercised, and I still am, as you might be able to tell slightly exercised, but very exercised. Once I get exercised, I face the gym. Anyway, so these are the various things you can use, all terribly interesting if you're in the coercion and control in the intimate relationship zone. But that is a great big hole. So we've got the great big hole, and I was doing a masterclass the other day for Kingston, having done one for Richmond, on coercion and control with capable adults. And I very deliberately put capability in inverted commas. Because one of the running themes is, how do we know the person has capacity to decide whether to continue living in that situation or not? I'm excluding for present purposes self-neglect. I'm talking about the situation where someone is in a complex social situation. So yes, okay, we've got the law telling us you need to have, in order to fall within the scope of the MCA, to be unable to understand, use, weigh, retain information relevant to the decision because of an impairment or disturbance in the functioning of the mind or brain. And unless you have that link, you do not have someone lacking capacity. And so Mark was very polite not to mention he'd been overturned by the Court of Appeal. He mentioned he got it wrong in the Court of Appeal case, the one where he was overturned about the woman and the husband who was coming back having served 13 years for having committed offences. That was PC and NC, where the Court of Appeal said, unless you show the person's inability to make the decision is because they have something wrong with them, you have not established a lack of capacity. Fine, that's terribly easy to say. It is phenomenally difficult actually to get to grips with on the ground, where you have the person with a mild impairment and the controlling situation. What are they? Are they incapacitous in relation to that decision because they don't recognise and can't understand, use, weigh, retain that they are being subject to exploitation, say? And that inability to recognise that is because of their learning disability. Okay, that's logically coherent, but isn't necessarily always the case. There might be some people who genuinely have capacity to choose to remain in an awful situation. we have a real dilemma there. And of course, if they lack capacity, best interest kicks in. I mean, you could go to the Court of Protection, get a Court of Protection judge to do all sorts of excitingly draconian things. You also actually don't need to go anywhere near a court at all, on one level. If they have capacity but are vulnerable, you are trailing off to the High Court inherent jurisdiction. Just to remind you what the inherent jurisdiction is, the great safety net. The court's deliberately saying, we are not going to close the door on what we will do. MCA covers one cohort of people, but there are loads of other people out there. So, inherent jurisdiction can be exercised in relation to a vulnerable adult, and the reason I keep banging on about vulnerability is not, I'm extremely well aware of its toxic nature in relation to the Care Act. The judges use it though. It means something to them. So either we just tell them they're wrong, or you have to roll with their right, and you need to grapple with what it is that they're bothered about. So vulnerability for these purposes, not incapacitated by mental disorder or mental illness, outside the scope of the MCA, but is, or is reasonably believed, under constraint, subject to coercion or undue influence, or for some other reason deprived of the capacity, that really means ability, to make a relevant decision, or disabled from making a free choice, or incapacitated or disabled from giving or expressing a real or genuine consent. And that's just there, if you want, that gives you all the sorts of things which Mr. Justice Mudley back then said he was giving by way of example. All sorts of different things. Just by way, just interestingly on coercion undue influence. Really interesting reminder there, where the influence is that of a parent or other closely dominated relative, and where the arguments of persuasion are based on personal affection or duty, religious beliefs, powerful social or cultural conventions, or asserted social, familial, or domestic obligations. It can be subtle, insidious, pervasive, and powerful. Very little pressure may suffice to bring about the desired result. People enmeshed. Not a great deal, depending on how they perceive their interrelationship socially. Very little pressure can give rise to undue influence. There is a marvellous case from the 19th century about nuns. A really interesting case of undue influence. A nun said that she had been subject to undue influence to hand over all her money to the religious order. And the judge back in the 19th century said, yes, she had. The gift was void. And she said that the Mother Superior of the order had acted with no malign influence whatsoever. But this woman was in a religious setting. She thoroughly believed the order of the Mother Superior that she had to hand over all the money to serve the purposes of God. It was quite enlightened and interesting stuff. But in the 19th century, this judge said it would require very little in that context to amount to undue influence in that closed setting. It's so often interesting going back and seeing judges grappling with problems in the 19th century. They weren't all evil. Sometimes they had some really interesting, they used language we wouldn't use, but actually human beings have been human beings over time. And we relabel things in modern language, but they're grappling with the same dynamic. So, and the bit which really got me exercised is the inherent jurisdiction. They say being used against people, is it meant to be facilitative? The Mr. Justice Hedley approach, I just said, if Sir Mark was still here. In other words, directed against the third party, against the perpetrator. Go away, stop doing it. Get out of the house to allow someone in to talk. Go away and leave this person alone. Well, we want that. I think that's what everyone would like. But the inherent jurisdiction can also, so I've forgotten to put it up there, there's a case of the judgment of Mrs. Justice Parker, NCC and TB, where she said, in fact, the person didn't have capacity, but even had she had capacity, I would have said this person should have been deprived of their liberty in the care home to stop her existing in this codependent relationship with her alcoholic, they're both alcoholic, with her partner, with her husband, which is all she wanted to do. I mean, by the way, at that point, what's the point of the MCA at all? And some of you, any of you, the seminar where Jonathan Herring was speaking, that's why I have a real problem with the idea that you just get rid of all the problems with the MCA by just moving to the concept of vulnerability and going to the inherent jurisdiction. Because where does it stop? Or at least where does it stop without a set of principles? So the proposition is, and we might disagree with this, we might unpick it, we might chew over it based on what we've talked about today, what you've heard today in particular from Sir Mark's very interesting ideas, that when in doubt, put the threshold of capacity on the floor, which is really what he was saying. In some of these situations, one should say, this person simply does not have capacity to recognise the degree of coercion to which they're subject. That person lacks capacity. Do we do that? Or does one seek to maintain an idea of capacity at some higher level? In other words, you have to establish more to show the person lacks capacity, which in lots of other zones you want to. Think of all those zones where we spend absolutely blinking ages training people, that the mere fact that someone doesn't agree with the medical treatment that the doctors want to give them does not mean that they lack capacity. So you've got these interestingly different things going along. So I think there is a cohort of people who really genuinely might be uncomfortable about saying lack capacity for purposes of the MCO. They are in some way vulnerable, to use the language of the courts, to coercion or duress on the part of third parties, and they are definitely not in the scope of domestic violence legislation. Really good example, Tuesday Friends. This was given an example given to me by an organisation who works with autistic people. So, get the benefits on the Tuesday. On the Tuesday, all the people descend on him to go down the pub, and he buys them all drinks. Come Wednesday, don't hear of them again. Now, they reappear every Tuesday. What is going on there? On one view, that looks very much to anybody else like exploitation. It might be this guy actually has got capacity. He says, I don't really care. I know these people are freeloading off me, but they're the only friends I've got, and I don't mind that that's the way it goes. That might well be the case. It might well be the case that actually he doesn't. He may have capacity, but he may be being coerced by these people. You just don't know. So, do we possibly want to think about, this is what I was tentatively suggesting to the Law Commission, but then I'm actively suggesting the Law Commission, and they were very interested. They were very interested because they could see the point. Do we want to set down in statute the scope of those to whom protection should be afforded, having regard to the relevance of disability? Are we necessarily talking about people with disabilities, or are we talking about people who are situationally vulnerable? And having regard to the provisions of Articles 12, the right to legal capacity, 3, the right to dignity, 12, capacity, and 16 of the rights of persons with disabilities, the state's obligation to secure people with disabilities from violence, exploitation and abuse. So much of the debate about the CRPD focuses on Article 12, the right to legal capacity, framed as basically the right to tell the state to go away and stop interfering in our lives. That's a very pejorative way of putting it, but that's how it's framed. How does that square with the state's obligation to secure people with disability from violence, exploitation and abuse? Well, of course, at one level it says, go away and prosecute those people carrying it out. But is that always what one does? Is it always the way out? Should we clarify the basis of and the rationale for intervention in the affairs of those people who are considered vulnerable? Should there be a guiding set of principles, as in the Adult Support and Protection Act in Scotland? So reining in the inherent jurisdiction, because that's what bothers me about the use of the inherent jurisdiction. Total discretion with no set of principles. If the vulnerability is the wrong term, because when I did a kind of consultation I put on my website, I had lots about this is what I want to do. Loads of people gave me really important and interesting examples. I had lots of very, very cross social workers telling me, how dare you propose this? I had several social workers saying, we see where you're coming from. Lots of other people saying, we see where you're coming from, including a number of people who themselves recognised that this was the position that they'd been in and would like some help, please, thanks very much. Which I thought was quite telling. It's not a formal consultation. I'm not going to place evidential weight on it one way or the other. But it was telling to me who was coming in at me. Lots of people saying, could you please stop using the term vulnerable? So I don't really care what we call it. I mean, I do care what we call it, but I'm using the term vulnerability because that's where the judges have come from. So the judges, who are the people at the moment unleashed in this zone, need to have some reining in. So we have been here before, interestingly. You may or may not remember, back in the day when the Law Commission came up with what became the MCA, they recognised there was a cohort of people that you might want to think about. They had an entire section of public law protection for vulnerable people at risk. And they said, we need to sit down and think about what we do with these people. The government, and this is one of those things I'd love to know, Jill, actually, where these consultation responses actually are. The government simply said, when they took it forward, what became the MCA, the government has decided, in light of the responses to the consultation, a number of issues raised in this, the original the government's paper of consultation shouldn't be taken forward at this time, including public law protection for people at risk. They didn't give any reason, they just said we're not going to take it forward. So I suggested the Law Commission, for their 13th programme of law reform, would you like to do it? They were very interested. Government has got other things on its mind, was basically. One interesting, I mean, I actually, anyone even updated what's going on, I don't know. The Home Office has been consulting on domestic abuse, in particular having a statutory definition of domestic abuse. I got myself levered into them through Action on Elder Abuse. We had a meeting with them, and I pointed out, you do realise that when you codify domestic abuse, you will make it very clear who is not within that zone. So could you please, before you codify, recognise who you are leaving out? And I came up with what may be a fairly lame term, but it was to me trying to get across the idea of the two missing categories. And the term I came up with was proximity abuse. So you've got two cohorts here. One of them is physically proximate, living under the same roof, the cuckoo, the lodger. Physically proximate, paid carer. They're there under the same roof, but they're not in an intimate relationship, so none of the domestic abuse stuff would apply. Although what is going on looks identical to what is going on in the context of domestic abuse. And the other is emotional abuse, emotional proximity. The Tuesday friends, possibly. The situation where someone, if they were a child, we would say this person is being groomed. And there was a big report come out, one of the multiple endlessly depressing reports about sexual exploitation. One of the reports related to people once they'd turned 18 and pointed out that there really was nothing that could be done at that point. Not an intimate relationship for purposes of the domestic, if you read the definition properly, it's not an intimate relationship that these people are being led into thinking. So, in the context of that, one might have an idea of the offence of coercion and control within the context of proximity. Which, I mean, I'd say criminal offences are good because they make it clear that what you're doing is you're targeting the perpetrator. You're not picking on the victim. I appreciate there are massive issues when the perpetrator themselves are vulnerable. That's just the ones I can say analytically with perpetrator victim. Obviously they are not, that is backwards facing in the sense of an offence must have been committed in order to be prosecuted. I mean, the police can turn up, Maria, she's still here, when she was in the police, could still turn up to, I think you are committing an offence, which has got a certain kind of sort of threatening power, but it doesn't actually stop, it doesn't give the powers to get in. So I think the emotional abuse or the proximity abuse would sit alongside, potentially, a reining in and a codification of the inherent jurisdiction. That's what I think. You may also think, and I'm just going to use a shameless opportunity to plug that book there, Overcoming Challenges in the Mental Capacity Act. You may also think, let's just get much bigger about saying loads of people lack capacity. If it's all too complicated to try and be clever and say, or be truthful at one level and say, these people have capacity and are being coerced, then just get much, much heavier on saying, this person does not have capacity to recognise that they are being abused. And go and say that you can go and take steps in their best interests. If you want to string that argument together, you can use this book here, written translation of a book by a philosopher called Camilla Kong, all about relational autonomy. I helped to translate it into English. It's very brainy. I barely understood it. This is designed to be more practical. And what it really says is it's providing, and I fully recognise this is high octane stuff. This is the ethical framework within which one locates what Sir Mark Hedley was arguing for this morning. In other words, you find the person to lack capacity so that you can take steps in the name of their best interests which are actually going to secure their true autonomy. So because it's much easier, because we've only got one piece of legislation at the moment, stick them in the MCA and say, take steps in the name of their best interest, for instance, to kick the people out of the house, to do the various things that you want to do. It's high-octane stuff because, of course, we recognise if you get people into the name of best interest, you may very well be in the zone of saying, oh, we'll just do what seems easier to us as professionals. But there is an ethical argument. There's enough of a legal argument that you can string two and two together to say mild impairment, inability to recognise, you can rationalise it as lacking capacity. So that's what Sir Mark was saying this morning. We haven't coordinated, but that is actually what he was saying when you unpack it. I don't know. It's you can get there. I think sometimes you might go, I'm not sure how I'm going about arming social workers, doctors, healthcare staff with these powers. Don't know. Anyway, that might be a way in which to wrap up some of the things you've heard over the course of today. But certainly for me, this series has been absolutely fantastic as a learning journey, thinking about all these different aspects, chewing at them repeatedly over the course of years from different perspectives. So that's me now, bang on 4 o'clock, so I'll shut up. I think we've got a discussion now. Yeah.
High octane circle, I think. Before I open it up to the audience, just to remind you that if you have to leave before 4:30, would you take out your evaluation form from the pack, which you completed? And I think there is still a table just outside the door, and if you would leave it there, then we will collect them up and use them and deal with them. Yes, thank you very much. How are we going to deal with it? The planning group being those of us who are here today, Pete at the back, Bridget, Paul, Jonathan, Alex, myself and Alison, who can't be here today, nor indeed tomorrow. We're going to meet tomorrow to plan how we take forward the energy from the seminars, 9 of them over 3 years. So you will be hearing from us in due course. Do look at the Sally website in due course, because we will post up there what we are planning to do in the future, and we'll also circulate information through the various channels that we've constructed over the 3.5 years or so. Oh, and the film from today will also be up alongside the films from the other sessions. Okay, first of all, any comments or questions for either Bridget or Alex? Paul.
Alex. Okay, so maybe start with Alex. Undue influence has been on statutes in the UK since the 17th century through Francis Bacon. What has it taken us 300 years to start to use it?
Well, we have been using undue influence. I mean, it's been one of the tools down the back of the legal sofa for years and years and years in relation to unpicking things about money. Because then, by and large, being very blunt about it, it's only been of interest when there's been stacks of money at stake, generally wills, gifts. So it's only much, much more recently that people have started to grapple with the relevance of it in the context of, well, it comes up in medical treatment cases in the kind of 1990s. People start recognising, especially in relation to things like Jehovah's Witnesses, there started to be a degree of edginess about it. But I think one of the things which is really complicated is that it's always, I mean, all the stuff about wills and gifts have been backward looking. So you're reconstructing a whole set of events to draw up a story and say, at that point, was that person subject to undue influence, to set aside something that they have done. What's getting more interesting and more complicated here is when you're doing real-time stuff, saying this person is currently subject to some kind of undue influence, we wanted to intervene. And it's not surprising that it was Sir James Mumby who kind of discovered it in that SA case in this zone, because he was, and he's just retired, but he was one of the kind of most historically minded judges So most of his judgments start, not normally 17th century, they normally start 19th century and kind of ramble on. But here this was quite useful, I think, because he really was pulling together a load of tools from down the back of the legal sofa.
Other questions in relation to Alex and or Bridget's presentations before I open it up?
I wonder if I could get Bridget, because you were really sort of short on time, I think. I'd be really interested to hear more about the interaction between the Convention on the Rights of Older Persons and the Convention on the Rights of Persons with Disabilities, in particular in relation to the autonomy discussion which things like this.
It probably requires more time than we've got, but what's interesting to me is that the Special Rapporteur for the Convention on the Rights of People with Disabilities is strongly supportive of the need for a convention.
Bridget, can you speak to the room rather than
sorry.
the back?
Sorry, so what I was saying was, I don't have enough time to go through this fully, but one of the very interesting developments is that the person who is the Special Rapporteur for the Convention on the Rights of People with Disabilities is strongly supportive of the need for a Convention on the Rights of Older People, has talked a great deal and presented reports about what she sees as the key differences and the fact that the Convention CRPD doesn't actually cover the needs of older people and is actually pressing pretty hard in open sessions that are being held to get a move on and to stop messing about, because we're currently this summer was the 9th session, not actually 9 years, but if I say that the list of topics that were drawn up of where the gaps were, I think it was 18, everybody was very despondent at that point from the NGO sector, because they said if we take 2 a year, that's going to be another 9 years to get through the full list. And the rapporteur was actually saying the CRPD is very useful at doing what it does, and yes, some older people are covered by CRPD, although they may not recognise that they're covered, particularly because member states might not be informing people, older people with disabilities, that they're covered by that convention and encouraging them to claim their rights. But she was actually saying, there is a clear need for those people who would not be covered. There's a vacuum here, get on. And perhaps we can talk outside to defend some of that.
Okay, if we open it up, thank you Bridget, thank you Alex. If we open it up more generally for any comment about today, and any comment about what you might want the planning group to plan in the future. So anything about today or the future? Yes?
In terms of the Mental Capacity Act and the Mental Health Act and the consultation, we talk about fusing the two together. What would be your views on that?
Northern Ireland have done it.
Well, they did it, and then they exhausted themselves so much they shut down their assembly and they're now doing nothing.
But the Act does bring the two together, Northern Ireland Mental Capacity Act, TE16.
Yep. Yeah, it's very interesting. I mean, the Northern Ireland Act is it came from, as you know, I'm sure, a really strong idea that the only thing you can do to eliminate discrimination against people with mental disorder is to fuse the legislation. They fused it on the basis of mental capacity, and they were thoroughly depressed to discover with about 80, I think they've been working on it for 8 years, and they were about to get the thing, it was before the assembly, before someone pointed out, you do realise it doesn't comply with the CRPD at all. And they were really cross, because they really had come with a really strong, positive, this is why we're doing it, and they're thoroughly miserable about the fact that, according to the Committee on the Rights of Persons with Disabilities, mental capacity is not a legitimate basis upon which to remove someone's ability to exercise their legal capacity. There is an almighty argument about that which is beyond the scope of this, except that if you do want to fuse legislation, you do have to be aware that if you want to be CRPD compliant, you are running bang into something which is you're moving in the wrong direction as a country. It's also, I think, I mean, one of the things that the independent review of the Mental Health Act is doing, I'm the legal advisor to it, but I'm not speaking on its behalf. One of the things it has been asked to think about is fusion. And I think one of the things that the review is extremely well aware of is before you go galloping off down the line of saying you need to link mental health and mental capacity, you may need to stop and think how happy you are actually about mental capacity. I mean, not at a philosophical level, not at a CRPD debate level, but actually to pick up on the things which have been going backwards and forwards. For instance, the presumption of capacity. How likely is it that people are going to hide behind it when it's convenient to say you've got capacity, or rampage over someone when it's convenient? And there's also, which I think there's a lurking fear about the Northern Ireland Act, if and when it comes in, is that truckloads, which is the technical term, more people are going to be detained on the basis that they lack capacity. So the cohort of people who would have been detained under their mental health order and are currently being detained under the mental health order would be massively increased on the basis of lack of capacity. The other issue, and my personal issue, the more I think about it, the more uncomfortable I am with the Northern Ireland legislation talking about best interests, is that I think that is problematic because they have to give a very weird definition in their codes of practice, which they've written, to say it can be in your best interest to stop you going off and doing something to somebody else in order to basically stop you being prosecuted, which is a very peculiar definition of best interest when we spend lots of our time trying to say best interest is really supposed to reflect what the person wants, which is why the Law Commission on the Mental Capacity Amendment Project, or the Mental Capacity Deprivation Ability Project, was one of the strong reasons why we said, don't say best interest, say necessary and important to risk of harm to you or to somebody else, because then you're being honest and you can leave best interests for the bit that you want best interests for. So solely in relation to deprivation ability, I think saying it is actually in someone's best interest is a bit fishy. So there's an awful lot that one needs to think about before you just go, ooh, good idea. Adi?
Just an idea for future seminars, which kind of builds a bit on this point. The interface between legislation. So in particular, say for example, Mental Health and the Care Act around suicide. Housing legislation and the Care Act and adult safeguarding around the death of street homeless. I know these are quite topical, but I think we struggle around the edges. Another one would be children's legislation and adults legislation on safeguarding and that whole transitional safeguarding piece. So it's like not seeing adult safeguarding as a kind of siloed, isolated practice, but it's interfaced with all sorts of other areas, because actually that's what goes on the ground, and that's what people struggle with in terms of practice.
Yeah. It's also within the context of really, it's what Norman Lamb was talking about as well, fragmentation of systems. I mean, it's one of the things which is driving the review team slowly but inexorably to the brink of throwing themselves out of windows, is the fact that you've got local authorities are supposed to be securing people's well-being in terms of their mental health. How do you actually get systems which look at what they are doing when CQC doesn't inspect local authorities, doesn't inspect CCGs, who've also got responsibilities, who only inspect the trusts? How do you actually try and secure a pathway which says we are properly looking after somebody? I mean, at one level, that's how you reverse generations of privatisation and deregulation, which is impossible. But if you actually, how do you do that stuff practically in a world where you can't untangle it?
Anyone else?
We've finished them off, Michael.
I think we have, or we have, between us. Are you all done, as the auctioneer would say? In which case, I hope you found it useful. Please do leave your evaluation forms on the table as you go out, and you will be hearing from us at least through the website. Thank you, and may the course be good.